chargeman.
No. It is related to junior.
This case was chargeman. This page 171. Yes, chargeman. Not junior engineer. I'm sure I am. That is why we are questioning you. These people, Naheem bin Ibrahim and others, are chargemen. I think you should let me play the judgment. The commissioners were working for gain in post of chargemen. The petitioners were working for gain in the post of chargemen, electricity department, Andaman and Nicobar Islands administration. Fifth Central Pay Commission, constituted by the Government of India, submitted its recommendation in the month of January 1997. Clause 50.23 of the above recommendation at page 138 of the writ application prescribed revision scale of pay structure for engineering subordinate cadres possessing diploma in engineering. And the clause is quoted below. Now, Your Worship, the Andaman and Nicobar administration took up the issue of finalizing the left out case of granting benefits of the above pay structure by virtue of a communication dated December 26, 2001, issued by Assistant Director Admission at page 43 of the writ application. Since no step was taken by the authorities to extend the above benefits in favor of the petitioners, they filed an application before the Central Administrative Tribunal, Calcutta Bench Circuit at Port there, and the same was disposed of on 12 April 2010 with the direction upon the respondent authorities to take a decision with regard to the above claim of the petitioners. The Andaman Nicobar administration in turn informed the petitioners by an order dated dated this, that the above matter has been decided by the respondent number 1 before filing the above application by an order dated 17 December 2009, passed by the Under Secretary, Government of India, Ministry of Power. The petitioners filed another application before the Central Administrative Tribunal, Calcutta Bench at Port, bearing number this, and after considering grievance of the petitioner and merit, the learned tribunal dismissed the above application on 27th August 2012. Hence this application. We have heard the learned counsel appearing for the respective parties carefully, and we have taken into consideration and circumstances of this case. It is not disputed that respondent number rejected the claim of the petitioners on the following grounds. The diploma in electrical mechanical engineering was not an essential qualification for the post of chargeman in electricity department as per recruitment rules. The educational qualification required for the post of chargeman in electricity department were lower than the post of chargeman in motor transport. Now, you should pausing for a moment just to explain this. Because for the post of chargeman in electricity department, this diploma and degree was not an essential qualification. I will show from the recruitment rules. And in the transport department, it was an essential qualification. It was higher than the chargeman working in the electricity department. So for these two reasons, it was rejected. Ministry rejected it. Now, taking into consideration the above grounds, the learned tribunal held that the decision-making process of the respondent number 1 was legal and valid. After perusing the recommendation of the Central Pay Commission in respect of engineering subordinate cadres holding diploma in engineering, we find that the grounds shown in order dated this were extraneous. There was no this in respect of engineering subordinate cadres. Judgment holding diploma. Yes, I'll agree to that. Diploma in engineering. Those chargemen who were diploma in engineering were granted this particular order. And the non-diploma were left out. Now, these non-diploma holders came to know about this particular notification of the Government of India. When junior engineer non-diploma holders were granted. So they wanted, when you have granted it for junior engineer non-diploma holders, why you are not granting it to me? When we are discharging the same duties as that of the chargemen, other chargemen for diploma holders. You have taken into consideration with regard to junior engineer. Why for us you are not taking into consideration? This was the aspect which was taken into consideration by this Honorable Court in the earlier round of writ application. Kindly see the judgment of this Honorable Court. And this Honorable Court specifically directed the tribunal, you look into this issue, why such discrimination is there. The tribunal completely ignored that particular decision of this Honorable Court and said, Government of India has taken a decision, so we cannot do anything. That was the thing which is required. Please explain this previous page. Yes. 174. It is last para. It is not in dispute that respondent number 1 rejected the claim of the petitioners who are chargemen. On the following grounds. Yes. Second ground we have understood about transport. First ground is the diploma in electrical mechanical was
not an essential qualification for the post of chargement in electricity as per the recruitment rules.
Yes, sir.
So if it is not an essential qualification, a person, how does this analogy goes to reject the claim?
Because in the transport department,
Transport you forget, diploma in electrical and mechanical, for that a diploma is not an essential.
not an essential qualification. It is not an essential qualification, which goes to show that chargemen who were inducted into the service, they may be non-diploma, they may be diploma also, because the diploma is not an essential qualification.
So your argument is that when this court in the earlier round of litigation has given the benefit to your counterparts
Counterparts,
who are also non-diploma holders.
no, they were diploma holders.
They were diploma.
Diploma holders. My contention is that not that they were non-diploma holders and they have been granted. When after the judgment was passed, the respondent authorities granted higher pay scale to the chargemen, making parity with the junior engineer who were only diploma in engineering.
Very good.
Now, what happened thereafter? The government of India has taken a decision that non-diploma holder junior engineers should also be granted the same pay scale.
That is 21st of August 2008.
Yes. Now, this,
Page 219.
yeah, you know. So, one particular decision was there by the government of India. These petitions submitted representations before the authorities. You are granting to the junior engineer non-diploma holders in the same subordinate engineering cadre. Why that benefit is not extended to us? Why there is a difference? We are also chargemen. Chargemen diploma holders are getting higher scale. Chargemen non-diploma holders are not getting that particular scale. I admit, Your Lordship, there are decisions of the Honorable Supreme Court that on the basis of qualification, there can be a difference in the pay scale. No doubt about it. But my point is that when you have taken a decision with regard to junior engineer, non-diploma holder, and that pay scale has been extended, a higher pay scale been extended to junior engineer, why it is not given to us? And this particular issue, initially it was rejected by the tribunal. I came before this honorable court. This honorable court found without any solution and said that why it has not been, and that has to be adjudicated. The learned tribunal,
Through the order of the court.
Your Lordship. Your Lordship, page number 240. Now, even Your Lordship, I will explain with regard to Jal Jeevan Ram also. Why I was insisting and why the Honorable High Court called found parity.
So your argument is when junior engineers, non-diploma holders have been given the scale. And as on that analogy, your counterparts have also been given, who are non-diploma holders.
Diploma holder, junior engineer given, diploma holder, chargeman given.
Right.
Now, non-diploma junior engineer have been given,
Huh.
non-diploma chargeman has not been given.
That is what.
I want how you have extended the benefit to the junior engineer, non-diploma holder, the same thing should be given to us. When you have applied the analogy, when you have extended the upgraded pay scale by applying the analogy, the junior engineer diploma holder should get it. They were given, we were also given. When we came before this honorable court has said, no, chargeman diploma holder should be given. Now, Government of India thereafter took a decision, non-diploma holder junior engineer should also be given.
But that is in 2008, madam.
You must
That is
be-
prior to the order of Justice Gupta.
Yes, before Honorable Justice Kar Gupta, only diploma holder approached. Non-diploma holder did not approach. They did not approach. Only diploma holders approached. Because they were not knowing about this particular notification of the Government of India. Subsequently, when they came to know and they found that junior engineers are getting that particular higher pay scale, so they submitted representation. And we have crossed that, Your Lordship. We approached this honorable.
This contention of yours, where is that reflected in your representation?
Your Lordship, kindly come to, it is there, just.
You are asking us to come to the just other order.
No, we have submitted representation. In the representation, we have in detail mentioned. That representation was, the tribunal has asked us to submit a detailed representation to the authorities supporting that government of India's order.
21st August.
Yes, we submitted the representation. When it was rejected, how it was rejected, very peculiar thing. Rejected on the same ground as it was done in 2009 with the government of India. But diploma is not an official qualification, and transport department they are doing they are diploma holders. Same ground, they rejected it. That's why I wanted to show the decision of this honorable court, Your Lordship.
Can we distinguish that certificate holders, non-diploma holders, that means that
Certificate holders.
certificate holders.
Certificate holders.
Yes.
Yes. In general engineers, they are also certificate holders. Non-diploma certificate holders. Yes. Your Lordship, it is at page number 122. I could remember.
This is after judgment of Justice Calcutta.
Your Lordship, yes.
This is 19.
After that, we had been to the tribunal also. Your Lordship, may kindly come to page number 118. We went to the tribunal. This is the second round of litigation, Your Lordship.
Oh.
We went to the tribunal 118. Tribunal has given us liberty. You make a comprehensive representation.
Mhm.
Then we submitted the representation, which is the
So that para where you have argued this. There you have said that your counterparts who are similarly situated have been
yes.
done.
Kindly come to page number 122, second paragraph.
Yes.
In terms of the order passed by the Honorable Court, the same was extended to Naheem bin Ibrahim and others, but I have not been granted a set grade pay of rupees 4,200, though I am also working as chargeman, and the duty and responsibility of both the chargemen are same. As I have not been granted the grade pay of rupees 4,200, and accordingly through our union, a representation was made on this to your good self for extending a benefit of grade pay of rupees this at par with the other chargemen of the electricity department as well as the other department of the administration. On receipt of the representation, the Assistant Director Administration Electricity Department had forwarded the same to Deputy Secretary Power with a letter dated this along with the comparative statement, and the union had also sent a representation to Secretary 7 Central Pay Commission on 11 March 2015 requesting for upgradation of grade pay of 2,800 to grade pay of this, but in spite of the same, no action has been taken for upgradation of a grade pay of rupees this to this.
No, that is not reflected. Your argument.
It is all I am similarly situated with that of the same chargeman, same department, same chargeman.
So your argument is pursuant to Justice Calcutta's orders.
Yes,
All diploma holder chargemen have been given. Given the scale of the upgraded scale, which was being enjoyed by the junior engineers also. Now then the central government came with a decision that non-diploma holders junior engineer will also be given. So you made a representation that you cannot discriminate since non-diploma, you cannot discriminate since we are doing the same nature of duties with the junior engineers and we fall within the same subordinate engineering cadre.
yes. Same duties as that of the chargeman, not junior engineer. And we fall within the same engineering cadre.
No, diploma holder chargeman was given. There is no confusion
Yes,
with
yes,
that.
yes, yes.
But non-diploma holder chargemen were refused.
Yes,
Now this you are saying that non-diploma holder junior engineer were also given.
yes.
Then how you get a right to say
Because we fall in the same engineering cadre. Earlier, when diploma chargemen were given, it was given only when the chargeman and junior engineer are under the same engineering cadre. When junior engineer was given, chargeman was also given. Junior engineer diploma holders were also given higher pay scale. So when the fifth commission decided that engineering subordinate cadre should be given upgraded pay scale, it was extended to diploma junior engineer. It was extended, but to us it was not extended. But finally, before this honorable court, not we, diploma chargeman, we found it, and the honorable high court found that engineering subordinate cadre, it was already given, but also the engineering subordinate cadre should also be given.
So chargeman diploma holder got it since they are under the same cadre, and since junior engineer diploma holders were given, the chargemen holding diploma were also granted.
Granted. Now the story finishes there,
Yes.
Then came the 2008 notification to the light of the petitioners here. Earlier, the petitioners were claiming the right only on the ground that chargemen, they are also working in the same identical duties. We are
What difference did it make? We are the subsequent circular of 21st August 2008.
Because, Your Lordship, the difference is that
The non-diploma holder of junior engineer were extended the
Yes.
benefit.
So I am saying that because I cannot argue the point, Your Lordship, that I am less qualified, though I am discharging the same nature of duties, I should also get, because I am less qualified. So these people,
So was that finding injustice in the earlier round of litigation?
yes,
But what will be the utility? The union does not appear, we cannot deliver our judgment. Again, we have to rehear the matter. So, sir, you also take this instruction if you are saying, what is your contention?
Lord, my contention is, my Lord, I clarify the two aspects, my Lord. They say that the chargemen, those who are holding the diploma holder, they approach to the tribunal, saying that as per the fifth
Yes,
pay commission recommendation, 50.53,
Very
because it says a subordinate cadre. So we are also holding a diploma holder, so we are entitled. The
good.
court has passed a judgment. The ministry has perused it, and in compliance to this court, the ministry has granted.
Right.
Lord, the other aspects, the non-diploma holders, because prior to 2004, the certificate holder, the fitter, the mechanical the fitter as well as the mechanical, because they are the feeder post to be held as a chargeman. Fitter in the grade and as well as mechanic.
No, let us not go into that. Hard contention is now junior engineer who are non-diploma holders.
Yes, Lord.
They have also now been given.
Yes, ma'am.
So
That's what I'm clarifying, my Lord. Not at par with others, those who have been diploma holders. These persons has to be treated because they have already, in terms of the earlier recruitment, they are the feeder post. And if the person was not holding a non-diploma holder, they have to give a pay scale at par with the junior engineers because they are the feeder post of the junior engineer.
which one was the feeder post of junior engineer?
The lineman come meter reader, my Lord.
That was feeder post of chargeman.
No, my Lord. May kindly come.
It is there.
Kindly come, my Lord.
both.
My Lord, we kindly come to page 186.
You only answer our query when non-diploma holder junior engineer has been extended the benefit. Why that benefit cannot be extended to non-diploma holder chargeman? This is the only issue you answer.
Lord,
To that effect, there is a initial prima facie finding of the High Court,
yes.
and it was relegated upon setting aside that order. Now the tribunal, when it was passing, there is nothing in the order which deals with the prima facie finding of the court. That is the subject matter of challenge. Now, if you can show us anything that no, sir, you cannot compare the diploma holder junior engineer at par with diploma holder chargeman, then the case will be different. It had never been your case that chargeman was the feeder post for chargeman was that line meter.
Yes.
Line meter upon promotion will come to the chargeman.
Yes.
So how that dislodges the petitioner's claim, because you are giving the fifth pay commission benefit. Subordinate engineer cadre has been given.
Yes.
It is not in dispute that chargemen also belong to the same cadre.
Lord,
The
that
only issue is diploma or non-diploma. Diploma, no problem. Non-diploma, when non-diploma, the 21st August 2008 circular says that non-diploma junior we are giving.
yes.
Then why you are not giving?
Non-diploma junior engineer, how they have come to that cadre may kindly see, not because the earlier recruitment rule, they are non-diploma, those who are holding certificate course, they are to be promoted to the post of junior engineer. No, my lord, for
non-junior, non-diploma,
diploma holder, those who are holding the certificate.
chargemen.
No, my lord, those who are holding certificates of non-diploma holder,
Right.
those who have been promoted to the post of junior engineer.
From which post they have been promoted?
From the post of, my lord, they have the feeder post of lineman come meter.
No. Lineman is the feeder post of feeder.
No, my lord, may kindly, that's why I'm showing, my lord, may kindly show 196, my lord,
Page 196.
196. My lord, 196, serial number 12, my lord. My lord, 196, serial number 12.
To the administration, he will forward it to me. He's not the. Yes, page
Road
200,
number 196, man.
page 196.
Serial number left hand side, my lord, serial number 12, junior engineer.
Serial number 12, yes.
Not degree or diploma holder of electrical engineer, mechanical engineer, my lord, fourth column, my lord.
Hmm.
Then, my lord, may kindly come to last column.
Hmm.
Promotion from amongst meter reader come meter testing having service of period of not less than 8 years in the electrical department in the grade. But this was the position prior to 2004.
Same is that of chargeman also.
No, I'm coming, my lord. May kindly come, my lord.
At the same time, you show that also, 14 number. Chargeman electrical.
So promotion from lineman to which post? To the post of junior.
Junior engineer, my lord.
Hmm.
Because there is a promotion avenue earlier recruitment.
Achha, now let us come to the chargeman under serial.
Yes, yes, yes. Serial number 13.
Same.
13, my lord.
Hmm. That is mechanical.
Chargeman electrical.
Let us come to the electrical 14.
14 electrical. Chargeman electrical,
Chargeman electrical, my lord.
not
197.
mechanical.
Promotion amongst, in the last column, you know,
Yes.
promotion from amongst lineman, assistant, lineman, fitter, electrical, with 15 years service in the trade and passing a departmental test
So
prescribed.
lineman was the feeder of chargeman.
Yes, my lord, that's why, my lord, because the parity
And they come to 12. Lineman,
lineman come meter reader,
who have 10 years experience.
yes,
They would be placed in the.
in the promotion to the post of junior engineer.
And here, there it was required 15 years. To become a chargeman,
Entirely
it is
different
15
aspect.
years.
For chargeman, the essential qualification is different. For the post of junior engineer, essential qualification is different. Earlier on, this recruitment rule, there was made as a feeder post. Not for sake of argument, I'm just not to permit. If a person who was holding a certificate course, he's a non-diploma holder, and if he has been promoted to the post of junior engineer, those who are non-diploma holder in 2008, as per the recommendation, they have been granted with the pay scale. Because a person who is holding a junior engineer, having diploma holder, already got it. A person who is holding junior engineer, being non-diploma holder, those he has to be treated at par with the pay scale of the diploma holder. So they also got it. So there is no disparity because they already been as a junior engineer with non-diploma holder.
Justice Korgutto's order, you have given all diploma holding chargemen
Yes, my lord.
the scale.
Right, my lord, because the scale,
In that case, how your analogy applies 2004 recruitment rules.
my lord, as per the recommendation, they say
If
that
you bring out if you bring out the case of this feeder post and promotion post, this was not argued by you before the High Court when diploma holding chargemen were extended the benefit.
Yes.
You could have argued that no, you cannot extend it to chargemen because their hierarchy and the promotional schedules prescribed under the recruitment rules are different in respect of chargemen and junior engineer. Now,
Yes.
the High Court has again prima facie finding has arrived, having arrived at a present relegated to you. Can you go beyond the scope of that High Court order and argue?
Absolutely cannot. I cannot go, my lord. What is
Please
an
take
observation?
instruction to that effect. What can we do? We heard this matter today, yesterday also, day before yesterday we heard. Not administration, if we pass an order against you also, affected party will be the Union of India.
Right.
So we have to hear Union of India.
Let it be on Tuesday, Your Worship, I will try once more.
Or Miss now you file a paper book, we stipulate it for final hearing. What can be done? This is the
Everything is
twice,
there.
because there is no scope for any inching on
No,
it.
no, no.
It
Everything,
has to be hard.
Your Lordship, everything is there in this one. Everything. Let us try on Tuesday once. If it is, if they're appearing, it's okay. If they're not appearing, Your Lordship, let it be in the next. I will not insist. If they're not appearing, I will not insist.
We have heard Ms. now learned senior advocate appealing for the
Order 41/11, Your Lordship. Admission. Judgment of affirmation.
yes.
Your Lordship, just in brief, Your Lordship, so that I can come to the question of law. The case of the plaintiff was that the defendant, being a family friend, used to approach the plaintiff and her husband and used to help them financially. Once it so happened that plaintiff required some money. Plaintiff requested the defendant, original plaintiff, now she has died. Original plaintiff requested the defendant that I want some money I require for the, because they had many children with them, 4 children were there, so I require some money. Now the defendant told her that, okay, one thing can be done, a part of your land, it was 300 square meters of land, that square meters of land, if you agree to sell it, I will act as your power of attorney holder. I will sell that land, and the maximum amount will be rupees 80,000, which can be given to you. Whatever extra comes, I will take it. And if you agree, I will give you rupees 50,000
For that land.
for that land, for execution of the power of attorney in his favor. He said, you issue a power of attorney in my favor. I will search for a seller. I will sell that particular 200 square meters of land out of 300 square meters
For
of land.
execution of giving me the authority, I will pay 50,000.
Yes, 50,000 has been paid. It is mentioned by the plaintiff. Now, Your Lordship, subsequently, the plaintiff came to know that she has been made to her thumb impression in the sale deed, selling the entire land to the defendant. That sale deed has been challenged by way of filing us by the plaintiff. Points were that points of contention was that this particular plaintiff and her husband, both it has been stated illiterate. They used to put thumb impression. The argument was that, Your Lordship, the plaintiff said that I was made to understand that it was a power of attorney. The entire deed was in that nature. And therefore, the sale deed is void in the eye of law because I was not read of the contents of that particular document. A fraud has been fraudulent misrepresentation case is there, fraudulent misrepresentation was there, and therefore the sale deed is to be declared as void. That was the case before the first court. Entire argument in the first court, even in the appellate court, the entire argument was relating to section 111 of the Evidence Act.
Evidence.
111 of the active confidence. These are illiterate people, admitted fact illiterate, they were used to put thumb impression. Now, an illiterate person puts a thumb impression and thereafter takes a plea that the document concerned has not been executed after reading over the contents of the and fraud upon them. Then in that case, what would be the situation, how the case has to be dealt with? That has been decided but not only by the Honorable Supreme Court, recently by this Honorable Court also in a second appeal. Then it has been held that it is the person concerned in whose favor the document has been executed is in active confidence. And if that document is challenged, then by view of attesting witnesses, the person concerned in whose favor the sale deed or gift deed or whatever document has been executed, he has to prove that the document has been executed with the knowledge of the person against whom that with the knowledge of the shifts. That is what is 111. Complete argument is only on that. They have not examined any attesting witnesses. They examined only one identifier. Honorable Supreme Court has held clearly identifying fire is not an attesting witness. Not that. Identifier has said that he has never seen the sale deed. Moreover, I will show from the document, Your Lordship, that there were 3 copies of sale deed. 3 copies. This correction has been made. The correction Your Lordship can find out in the place where the vendor put the thumb impression and the place where the 300 square meters.
The point of law.
Point of law is that, Your Lordship, whether
The factual aspect.
yes, I have framed the point of law, Your Lordship. My point of law is that whether in a case, when a case of fraudulent misrepresentation has been made, and when the party concerned is trying to be in a position that the active confidence is on the person in whose favor the document has been executed, whether the burden of proof to prove that the document has not been executed after knowing the contents of the same, after the misrepresentation has been proved, whether it will rest upon the plaintiff or the defendant. This is a question of law. And the Honorable Supreme Court, I will give the judgment, Your Lordship. The same happened. After the Honorable High Court.
Which ground you have stated that?
Page number 40, page number 30, paragraph 42.
There must be some special cloak of protection.
Your Lordship.
Special cloak of protection for the
Illiterate people. Even in the sale deed, Your Lordship, it was nowhere written. Rather than explained to the
that certificate was not there.
certificate itself is not there.
To show us the finding of the 2 courts.
Your Lordship. First court, Your Lordship, I am taking the first court.
বাবা এভিডেন্স একটা দাও তো এই মমিন এভিডেন্স একটা বের কর
Certificate must be there.
First court.
That it has been read over and explained to the.
That certificate is not there, you are saying. Read over and
No.
explained.
It's not there, 100%, your lordship. I won't say anything like that. I have the bunch of the.
We have to go through that documents.
Yes.
Power of attorney or whatever it may be.
Yes, your lordship. Your lordship, be kind.
Ekটু দাও।
There you go.
The entire thing is a plain written statement, everything is there.
No, that document, we want to see that document.
Other document, sale deed,
Evidence Act.
Evidence Act 111.
See the
नहीं पुराना पुराना
suggestion of substance relates to factual aspects.
Your lordship.
This is factual aspect, Miss Nag. Why should we interfere?
Not coming to the factual aspect, I told you.
You are saying that no certificate was there on the consonants of that.
Come afterwards, your lordship, at the time of filing. My only
That is the concurrent findings.
concurrent finding is not on the point that whose this burden of proof should be on whom. That finding of fact, your lordship, that point is not there.
Satisfy us to that.
Yes, your lordship. Your lordship, may kindly come to
First court judgment.
first court judgment.
Oh, Baba. Hello.
The first court judgment was completely
Yeah,
upon
that's
the
one.
perversity is always there, your lordship.
The first volume, the second volume টা নিয়ে
কেন আমাদের you don't have Bear Act আমাদের নেই
বুঝতে পারছেন
evidence act in the library it is not there.
কি দিয়ে দেখুন
ताकि हमको पेज नंबर यहाँ से बोल दे रहा तुम.
No, not the new one, old one. Evidence act. Oh, you are given. Sorry. Oh, it দিয়েছে Stephen. এই যে এখানে পেয়ে গেল. Take back. এটা নিয়ে যাও. এই যে দেখ.
proof of good faith in transactions. So I
Yes,
what
sir.
is in relation of deep confidence.
Yes. Because entire case, your lordship, the plaintiff's case was on good faith. Good faith had to become impression. It's the entire case of the
So it
plaintiff.
is not only, even it is applicable in respect of a literate person.
Yes, your lordship. That is the decision of the honorables because it used to be applied to Parbanishing lady. Then the honorable Supreme Court has said that it applies to illiterate people also.
There is a special scope of protection that has
Yes,
been
sir.
mentioned.
Your lordship. She was also suffering from schizophrenia. Document was executed. And the first court completely on schizophrenia only. But other than this, it was not only schizophrenia, it was specifically illiteracy. The document was executed. Your lordship knows schizophrenia is not curable.
Yes, sir. Whether there was any active confidence or not, whether there is friendship or not, it's a factual aspect. I think.
Factual aspect. I am not on that, your lordship. My point is that illiteracy is there. Illiteracy, there is no doubt about it. Now, your lordship, the decision of this honorable court and the honorable Supreme Court to that exact point, your lordship, it is there. Exact point,
We will show us the findings of the court.
your lordship. Inner page 4 of the 74, page number 70. Whether paginated or not, I am not sure, your lordship, because certified copy, if it is there, it will not be.
74.
Yes,
Internal page
internal 4. Internal page 4.
of the first court judgment.
Yes, first court judgment, trial court.
So issues.
Issues.
Yes, issues. From there only your decision starts.
Issue number 9. Argued plaintiff and husband. What is your occupation? What is the occupation of the person?
She was a housewife. The land was recorded only in the name of the original plaintiff, that is Muniyamma. Your Lordship, basically what I find from the judgment, issue number 9 has not been decided.
Then
What can I do, Your
that is
Lordship?
the first point I have raised.
Not decided even.
That's why.
Issue number
Yes,
9.
yes.
Issue
Issue
number
number
9.
internal page 7.
Your Lordship,
4, 6, 8 and 9 were taken in together.
9. Okay. I'm sorry, Your Lordship. I thought it is serially, that's why. Your Lordship. Your Lordship.
The plaintiff has further taken a plea that she is an illiterate lady. This contention was not opposed.
Yes.
Page number 12. In this written even I do not find it. As it can well be told that the plaintiff no doubt is an illiterate lady.
Both the courts have come to a final conclusion that they are illiterate. No doubt about it, Your Lordship. Because even defendant did not raise that point, that they are literate. No. They are accepting that she is.
Just.
Yes. Your Lordship.
প্লেনটিভই প্রমাণ করতে পারেনি ওই ইয়েতে ঢুকেছে। ফ্রড প্রমাণ করতে পারেনি, মিসরিপ্রেজেন্টেশন প্রমাণ করতে পারেনি। ওই 111 যে মানে শিফটিং অফ বার্ডেন অফ প্রুফ ওয়াজ নট ডিসকাসড।
Now, as the sin has been proved that she is an illiterate, burden has been shifted to the defendant.
Yes.
Is it correct?
No doubt about it, burden has been shifted. So at least one attesting witness ought to have been examined to prove that yes, sale deed was executed, the contents were read. None of the attesting witnesses were examined by the defendant.
Now,
And both,
I don't know whether my brother will agree that this court can entertain the factual aspect only when it will be seen that the learned judges did not apply the factual aspects, did not consider the factual aspects, and it causes a great injustice.
Your Lordship, the learned,
In that case, we can. I do not know whether
because both the learned judges said the burden of proof was upon me. Both the judges.
Section 111 was not discussed in.
Not even discussed. I have got the written notes.
So that ought to have been an argument. That ought to have been your argument.
Yes, Your Lordship, and I had just in order to avoid this.
You have argued fraud and misrepresentation.
You written notes are there, which I filed before the court below. That's why I am saying.
That may have been drafted by you now when it has come to you. You find it, there is where the act should be put.
1 minute, Your Lordship.
On the first court judgment, we do not find any argument on your behalf pertaining to 111. On the contrary, your specific
Your
argument
section-
was fraud and misrepresentation.
Section was not quoted, but my contention was always there that the defendant has not proved the sale deed. It was always there.
That is not there.
Your lordship, just 1 minute, your lordship.
Yes, it's a lengthy judgment you must. Or you can come tomorrow. We can give you time to go through it and come back.
Your lordship, I'll come tomorrow. I can mark and I can,
The second appeal, one stayed, gone.
yes, your lordship,
So one has to be, we will listen, we will hear you.
your lordship.
You please prepare yourself on that. এটাকে not today করে রাখো. Tomorrow it will be there. এটা একটু আমাকে দিয়ে দিও তুমি। মেমোটা পাঠিয়ে দিও। Where is the judgment you are showing? Give Miss Nag.
Yes,
Please
yeah,
give the judgment.
I'm handing you.
Give 2 copies.
I'm giving one more copy, your lordship. You do just.
ওটার সাথে
For left, right, issue,
কিন্তু expert. It is an expert.
Your lordship, these are the main 2 judgments, your lordship.
special proof of protection এবং অনেকগুলো রিলিজ খারিজ করেছিল। যেমন তোরা নিজের মাকে ভুল বুঝিয়ে নিয়েছি করে ছোটবেলা থেকে করেছি ওগুলো স্পেশাল প্রুফ অফ প্রোটেকশন আছে ইলিটারেট তারপরে তোর এজেড পার্সন এদের স্পেশাল প্রুফ অফ প্রোটেকশন তোমাকে দেখাতে
111 কিন্তু
অ্যাক্টিভ
100
কনফিডেন্স অ্যাক্টিভ কনফিডেন্স বন্ধুত্ব ফ্রেন্ডশিপ ছিল আচ্ছা কেউ রিলাই করতো দেখলো যেমন বাবা
So burden of proof will shift upon him. সেটা ঠিকই কিন্তু really what are the what are the steps on the basis of which these you can apply একটা একটা schizophrenic documentation দেয় illicit বলে ফোন করেছে
ইলিটারেট বলে যে করতে পারবে না তার কোনো দেখাতে হবে যে ও বুঝেছে এবং ওকে মানে বোঝানো হয়েছিল কন্টেন্টসে জানানো হয়েছে মিসরিপ্রেজেন্টেশন অ্যাজ টু কন্টেন্টস অফ দি ডকুমেন্ট অলসো দেয়ার
সেকেন্ড কোর্টের জাজমেন্টে দেখবি সেখানে টেস্টিং উইটনেস টেস্টিং উইটনেসেস
দেখতে হবে আর কি
একটু আই মে বি রং চেক
তো রেকর্ডটা পাঠিয়ে দিও
ইয়েস টুমরো এই ডেকে দাও উই হ্যাভ নো আদার
আর উঠবো হয়ে গেল তো সিরিয়াস
হ্যাঁ আচ্ছা বুঝলেন আরো চলছে ও আমি তো ভাবছি আর নেই আমরা ভালো করেছো ও আই মিস দ্য আই ডিডন্ট শিফট দিস পেজ তাই আমি তোমাকে রাত্রে ফোন করতে যাচ্ছিলাম আমি সকালে লিস্টটা কালকে চেম্বারে ঢুকেই আমি দেখেছি 2টো ম্যাটার আমার ওকে ধরবো বলে আমি ফোন করছি Yes, Mr. Kumar.
My lord, they have challenged the order passed by the writ court. There is an application for condonation of delay.
Item number 3.
My lord, I have got no objection.
You
to
are the appellant.
I have got no objection, my lord.
Upon hearing Mr. Kumar, learned advocate appearing for the Baba,
made an appeal, he made a second appeal to the LG. It went up to the LG, LG has not pulled the order of the part in the disciplinary proceeding that.
The read court set aside that.
Red court set aside that along with cost and all, the backdated cost and that. So this is the order.
So you have to argue on stay. If you don't have, very good, we will dispose it of asking you to file paperwork.
Yes, ma'am.
But if he proceeds in contempt, what happens?
Don't proceed.
My lord, the administration nowadays, they are not complying any order unless and until they go to Supreme Court. Unless and until they go to, in all the matters, my lord, in all the matters, not even a single matter. All the matters they go to Supreme. In this case, there is an order. In this case, it's an abuse of power by the authorities, my lord. I am 80% handicapped, my lord. I have joined a group which work against corruption. For that, my lord, I have been targeted. That has been observed by the court. And without any evidence, I have been thrown out of service. And there was a direction to immediately reinstate me. Not done.
So why didn't you file contempt?
I have to file contempt, my lord. If we file contempt, then also they will not comply. This is what going on unless and until they will go to Supreme Court or the. In all matters, my lord, I have personal experience in all the matters.
That is unfortunate.
But there are certain problems at the end of the government. When there are government matters, they have to go to.
In all the matters.
No, but Mr. Dwivedi, no, it is not a case. We are saying we have a hierarchical system of judiciary. In this, if your bureaucrats think that they will not comply a division bench order unless and until that is affirmed by Supreme Court, if this is the way of thinking, then everything gets prejudiced.
My lord, in one case, no, my lord, no, my lord. I am appealing in most of the matter I know. My lord, in one matter, my lord, there was an arbitration clause in a case. 7,50,000 was my claim amount. When the matter came before this court, Honorable Justice Sanjeev Banerjee told them this is a meager amount. He has supplied the amount, you pay the amount. They denied. Ultimately, an arbitrator was appointed. Arbitrator passed an award. That award was challenged in 37 before this court. SLP was filed. Review was filed. And thereafter, my lord, till date that amount was not paid.
That is because they don't like the advocate.
No, there are certain situations also where.
So, Mr. Dwivedi,
To challenge in time and the officials got suspected.
right, Mr. Dwivedi, if all the pleadings are on record, we can finally dispose of.
Then my lord. Come back tomorrow with all the, because I also received this paper.
Oh, just now you received.
My lord.
My lord, I don't think, my lord, all the documents are there. Only
All-
one petition is there.
No, affidavit opposition is there, page 197 of the stay application. And I think reply is also there. You must. এই একটা section 5 আছে।
Affidavit and reply नहीं किया।
Yes, ठीक है।
नहीं, reply to me.
We do one thing, we are Mr. Dwivedi, we are disposing out that the section 5, we allow that and we keep the stay application returnable on Tuesday. Or we can keep it returnable tomorrow also, you can come and tell us whether all the then if all the papers are not.
By that time, the Chakraborty will also come. And that will be at least, I have drafted this application, but it will be better if Mr. Chakraborty will get it.
Ashu,
I am not on the panel, that is my problem.
you are junior to Mr. Chokru, but you are not in panel. The present appeal has been preferred, challenging a judge
Your Lordship, my
কোনটা judge নিয়ে? ও আচ্ছা, আচ্ছা। On the prayer of the learned. Arey sir, how long will you take to file the paper book?
Lordship, Monday it will be filed positively, Your Lordship. Because it is a big paper book for more than 500 pages, Your Lordship. It is
To file it today, what is the subject matter? Miss Nag is there.
Your Lordship, my senior is appearing, Your Lordship. The paper book is under process, Your Lordship. I pray that this will be fixed on Monday. Positively, it will be filed by.
How many matters will fix on Monday? They are disciplinary proceeding.
After discipline, proceeding has been removed from it.
He has been removed. So removal order was challenged before.
Cat and cat uphold the order of the removal. That's what they are.
And this court. We keep it tomorrow, come with the paper, file the paper book in course of this day.
Lordship, I sincerely pray that it will be fixed on Monday, Your Lordship. Because it is a big paper book, Your Lordship. There are many pages that have to be
So
incorporated.
you have given sufficient time.
You've been given time, na? Is it
I'm
ready
saying
with
that.
you?
Your
Do
Lordship,
do you have with you to file it in the department? Na?
by tomorrow it will be fine.
So very good, then we keep it day after tomorrow.
That means,
Uh-huh.
that means Monday.
Oh, day after tomorrow. কি?
কালকে ফিক্স করো, কালকে ফাইল করো।
Monday was holiday month, yeah.
Oh,
ওই মানডে চলছে।
No, Monday was.
was it?
holiday.
Oh, today.
That's why they are.
Oh, কালকে last.
হ্যাঁ, কালকে ফাইল করে দিন না। বলো।
So you file it, it will appear on Monday.
Your Lordship,
Huh? You can supply a copy to him.
Your Lordship.
So just Monday कर दो.
Right, Your Lordship.
I have to mention one matter, three matters you'll have to, it is related to same eviction proceedings. So I have informed the other side, it's a writ petition, your lordships.
Eviction means Tehsildar order,
No,
deputy commissioner.
not of the deputy commissioner, airport authority. State appeal,
It was mentioned, one matter is already there in the.
it is already there.
Yes,
And these are the other two matters,
all right.
three matters.
Who is your other side?
Learned counsel, Mr. Jaipal, I have informed him.
Please state it. Affidavit, sir, any affidavit deduction was there?
Yes, there was a direction, I have filed my affidavit and there was a direction to file the reply.
They have filed it.
I think they have filed in the registry. They have not served me any copy. But I think it is not, it won't be required.
All right. Now today, which matter is that Mr. Kumar told me that.
That is yes, tomorrow it is fixed. That is matter.
That is
Let-
promotion matter.
Promotional
Oh,
matter.
acha, it listed there. Give it tomorrow. Yes.
Item one. Any message? My lord, item number 1 to 7, we have filed an affidavit officer in the registry. I'm giving the copy of the opposition. Already filed.
In all the writ petition.
All the writ petition, not connected matter.
So it has come, why it has come for today?
Mentioned.
Since time to file opposition lapsed long ago,
Oh,
actually the matter has been brought to the news.
so,
Let me deal with the opposition also on 10th, this can be disposed of. I'll use my reply in the meanwhile, on 10th, this matter can be disposed of. Common question of facts are not been raised in all this.
Mr. Hard Mr.
WPA 180 of 125.
Item number 8. আচ্ছা, ওই রেগুলেশনের বইটা দিও তো একটু। ওইখানে আছে। Yes,
No. No, yesterday I have stated that.
I forgot
Well,
it from the beginning.
yeah, that the,
Whichever the bad cases I forget, but good cases I remember.
it's a good case.
Yes, yes.
After the division strength order, as I have mentioned,
An arguing counsel should always say that I have a strong ground for interference. Yes, tell us.
this is
my lord, after the division bench order,
Hmm.
division bench has stated that it's a licensed land. And I've given the copy of the single bench also, wherein it has stated it's a licensed land.
Hmm.
The authority also accepted that it's a licensed land. In their submission, it is mentioned in the single bench also.
It is a license under regulation 4B2.
Two, it's a license. If it is a license and 4B2, first,
Now, please tell us what happened after the show cause.
after the chauffeur, the order has been passed. That was given yesterday, madam, that was
Sure.
given.
Now, you challenged first the show cause. Earlier,
No, my lord, the order was challenged, my lord. The order was challenged. My lord,
page 50.
my lord, that order, my lord, that page after 50, my lord, this order was passed. Yesterday I have given, my lord, that order also. It's dated, my lord.
So
About six-
against, no, this is a show cause notice under section 4.
my lord,
When you filed your reply, final order was passed by the estate officer. Against that, you preferred a statutory appeal. Thereafter, a revision. Very good. Now, they are going to demolish,
my lord.
evict you. Yes.
Now the order passed by the estate officer. My
Yes.
lord, that it
Yes,
has
show
dealt,
us.
it has dealt.
Show us, please.
My lord,
It is not annexed here.
that it is not annexed. The thing is that, my lord, on 30th, on Saturday, he came to me and Sunday I asked him to come and by Monday, Tuesday I have
Hey, what you want to show, please?
here. Kindly see the third page, my lord. Kindly see the third page.
Hmm.
They have given three questions, my lord. Three issues are there. Whether the land was a grant or otherwise, whether the period of grant is expired, whether the land should be restored to government. My lord, first issue, they have said in the page 4, therefore issue number 1 is settled, the land is grant land. There itself they have done the mistake, my lord. Because the Honorable Division Bench has stated it's a licensed land, public premises will apply, licensed land has to be revoked and it has to be declared as unauthorized land. Then after they can proceed with the PP Act. But when the license is there, this Public Premises Act will not come and the estate officer, he himself assumed that it's a grant land. That's why he has given this point issues by saying that, by assuming that it's a grant land. If it is a grant land, he has a right. But the division bench said it's a licensed land.
Yes.
Well, the second point also, second issues also, second para, therefore, issue number 2 is settled. The grant period has already expired during that. Because he assumed that it's a grant land, grant has given. So he has, on the basis of that, this order has passed. So this order, it has to go, madam. As per the division bench order. Because as per the division bench order, only after passing the division bench order, this estate appeal has initiated, madam.
Very good.
Because it is mentioned in the first paragraph itself by saying that while disposing the map 6 of 2018, title Andaman Nicobar Administration, Shamal Chaudhary, the Division Bench Honorable High Court on 20th September 2021, the portion of the order by which restriction of possession was granted is hereby satisfied. The appellate authorities are abstained from dealing with the property. So as per the division bench order only, this order has been passed. So they cannot pass this order, my lord. Because it's a licensed land. They assumed it's a grant land and passed the order. Well, if it is a licensed land, as per the Supreme Court's order, my lord, because the authority has filed an application, my lord, civil appeal 1810 of 2009. It has been dealt that if it is a license, then it's a perpetual license, my lord. It's a perpetual license. It has been held in this, my lord, this is the case, my lord, Collector of Land Acquisition versus Andaman Timber Industries. In this, my lord, the same thing happened, my lord. 30 years grant was given, but it was held that it is a license. Another 30 years can be given, and it is held that It's a perpetual license. So as per the perpetual license, as per the section 1966 Act, it has to be dealt with. It's, my lord, it's a page, paragraph 8, 9, 12 and 13 is the relevant paragraph. 8, 9, 12 and 13. It has stated that if it is a license, as per section 162, my lord, it has to be extinguished, then you can take the land.
But you have accepted it as a license. So license you accepted, your contention is, it is license once given, it has to be in perpetuity. Very good.
And the 1966 Act also says the same thing. 145A, it says, my lord. Because the earlier Act, it's repealed. So we have to go with the 1966 Act only, my lord. So 1966 Act 145A is very clear, my lord.
All right, yes.
145A says,
The Supreme Court judgment, you are referring to paragraph?
paragraph 8, 9, 12 and 13, my lord. I'll come to that, my lord. 8. Paragraph 8 is at page 9.
You have not finished with the appellate authority order. Please don't take me away from that order by showing one line. Please argue your case. You placed one paragraph and you came to the Supreme Court judgment. Let us know what is the problem here. Now, issue 2 was, so your argument is that the appellate authority treated it to be a grant land. Very good. Now, then what is your next argument? You want to show which portion?
My lord, this is the main mistake they have done, my lord. Division bench has ordered something else. They have dealt with something else, my lord.
Yes. Any other portion you want to show us?
No, my
Or
lord.
from the appellate authority
No, my
order?
lord. No.
What is how the issue 3 was decided?
Issue 3 is with regard to
Should be restored to the government or not?
my lord.
Please place this.
Issue 3, my lord. Issue 3 in this context, 38(1), Regulation 38(1) provides
Now
all
yes.
all land in the Union Territory of Andaman Nicobar Islands is vested absolutely in the government, and say was provided by under this regulation, no person shall be deemed to have acquired any property therein and any right to or over the same any occupation, prescription or conveyance or in any other manner whatsoever except by the conveyance executed by or under the authority of the government. As per section 141 of the said regulation, there are 4 classes of tenants: occupancy tenants, non-occupancy tenants, grantees, and licensees. I am licensing, mother. I am coming under the 141 licensees.
Please read the next paragraph.
The licensees as well as the grantees are classified as tenant under the Land Tenure 1966. There are 4 categories of tenants. 3 categories are licensees, 1 category of grantees. There are no other categories of tenants under the said regulation. The licensees are perpetual allottees. A grantee is granted land for a specific period not exceeding 30 years, with an option for renewal for a like period. In case of grantee, the land automatically reverts back to the government once the first term of grant period expires, or once the term of final option for renewal expires, or if the grantee exercises the option to surrender prior to expiry of the first term of grant. Now, material on record clearly brings forth the fact that the grant has expired long time back. The former tenant has no plausible reason to be in possession of the said land. Sri Shamal Chaudhary does not have any right to be in possession of the said property, as at no point of time the government or any authorized person has executed any conveyance so as to be in continued possession of impugned land beyond the year 1989. Moreover, the Honorable Supreme Court SLP that once the granted period has expired, then the grantee has no right to be in possession established by ratio dispute. This was done. And issues, therefore, you have the land is in the government.
So your argument, if we have understood, is that it was our claim was it was a grant. Your claim initially was that it was a grant.
Right.
But after single bench and division bench, it has been established that it is not a grant, it is a license. So having the license once granted will be perpetual in nature. So now please come to the division bench order. This is the argument of yours. This is the argument. Please come to page 41 of your writ petition. Please place indisputably, second paragraph.
Indisputably, the license was granted in the regulation 41B of the regulation 1926 for a period of 30 years, subject to the general conditions enshrined therein. The initial proceeding initiated between the parties would evince that such license was treated as a grant under regulation 41A of the regulation 1926. But such contention was not accepted, and therefore the respondent cannot contend it in the instant proceeding that it was a grant, not a license. The stand of the respondent at the latest stage of the proceeding would also corroborate the said fact when the respondent abandoned such claim,
Yes,
accepted the position.
respondent has abandoned such claim. Madam, the thing is, you are right. If a license is given, question of perpetuity is to be decided. Now the thing is, this proposition you have yourself surrendered before the appeal court. Your contention was only consider only whether restoration of possession which was directed by the single judge was turned down by the appeal court. So what remained was the conclusion of this proceeding under Estate Acquisition Act. Prior thereto, the estate, an order was passed by the Deputy Commissioner in terms of the regulations. It was held concurrently that Deputy Commissioner has no such jurisdiction to pass the order. It should vest to the government and it will be under estate acquisition. Now, after the estate officer concluded the proceeding, appeal court concluded the proceedings, the revision bench concluded the proceeding. Can you, madam, turn back and say that the appellate order is wrong?
But
Under what? No, Mr. Under, yes, jurisdictional point can be raised at any stage, but you yourself have abandoned.
thereafter only this.
Please, no, thereafter. You please show how, please satisfy us that you have not surrendered the contention of yours that it is not a grant, it is license, and you have to be in perpetuity. That was never your argument. After the division bench order, you have accepted, abandoned such claim. The stand of your first stand was it was a grant, 30 years.
I was praying for
Then it
another
was,
30 years.
huh?
I was praying for another 30 years.
You are praying for another. Now that on that grant issue, the waters have flown. Now, how can we give you this protection to reinvigorate a claim, which you ought to have agitated appropriately before the courts? Can I, being the writ court, sit in appeal over the revisional court order passed under 227? I cannot do so.
My lord, that is.
I understand your grievance, but the madam, the
Order.
yes, division bench order is, it is a license.
It is a license.
Now you said estate officer will take a decision. Estate officer took a decision. Show us that decision of estate officer
Hello. It's a,
that you have handed over.
my lord. He himself assumed that it's a grant land.
He himself assumed as a grant. Do you challenge this?
I've challenged this. I have not taken that point.
So even if grant, no, you have taken the point.
No,
That is why the issue was framed, whether grant or license. You took the point. Now it was said by the appellate authority proceeded on the basis it was a grant. It was a grant. That and the see your order of the revisional court. You have never agitated this issue, madam. How can I help you at this stage?
I'm accepting all this proceeding initiated on the basis by saying that it's a grant land. Estate officer said grant land, again the district judge, estate of,
Whether it is grant or license, grant will not be in perpetuity. It will be a 30 years. 30 years, but after 30 years, you can make a prayer for extension, but the regulation does not provide for.
but the citation is there, Manoj, with regard to that.
With regard to license.
With regard to license.
Yes.
It has held that it is a license.
Right.
After 30, in this also, my lord, after.
That
30
issue of perpetuity was dealt with by Justice Somen Sen while considering the writ petition in which the order of the Deputy Commissioner was.
Actual license, my lord, it has to be cancelled first. It has to be revoked.
That, why didn't you say that to the appeal court? You should have said that you, no, license grant, you first decide the issue. If it is a license, it's a license in perpetuity, you cannot remove me. Show that line. On the contrary, you accepted.
We have accepted, my lord, as a grant, my client has done the mistake.
Now you have accepted
But the-
it is a license, whether perpetuity or not, that was argued by you. Justice Sen refused that prayer. It came up to the division bench. That issue which you are arguing was there before the division bench.
But this,
But you yourself surrendered that issue. Page 41, you have surrendered that issue, saying that it is a license. See, in this way, license was granted for period as subject to the initial proceeding initiated was would evince that the license was treated as a grant under C. License was treated, but such contention was not accepted and therefore you yourself said now that it is not a grant.
no, thereafter, so it is there.
Such contention was not accepted and therefore the respondent cannot contend in the instant proceeding that it was a grant and not a license. Now thereafter, so grant you have abandoned. So it becomes a license. You're right. So license, the perpetuity has to be determined. So that the single bench decided that issue. Single bench left, did not decide that issue. The perpetuality was considered. Ultimately, it was said that jurisdictional error, that order should go. But that issue was not answered. When it came up to the appeal court, the issue was not answered. So you proceeded with the estate officer. Estate officer passed an order, appellate authority passed an order, divisional court passed an order. Now a writ court, if I pass an order, my order will be without jurisdiction.
No, my lord.
Yes, take down.
41, next para kindly be seen, my lord. Undisputedly, the period of license granted on 18 September 1950 was 30 years, which expires in the mid. The prior permission was granted by the authority to transfer and convey the restitutory period of license in favor of original licensee by executing the sale date. So all these things happened.
Yes,
My lord,
what, you finished? Anything else you want to point out?
once the Supreme Court, the Apex Court, what held, my lord. It was also the for 30 years. The grant was given for 30 years, but it was said that, my lord, this the authority can very well go with the this Public Premises Act, my lord. But the thing is that prior to that, they have to extinguish, my lord. License has to be go, my lord.
What has to be?
License has to go.
Hmm.
License has to go. First, it has to be declared. License has go. Invoked.
Hmm.
That has to go. It has to be terminated. It is not a license. Then unauthorized occupation will come. Then the Public Premises Act will come. My lord. Estate officer can act if it is an unauthorized occupation, my lord. If license is there, in that situation, my lord, I am not an unauthorized person, my lord. I am not an unauthorized occupation, my lord. License is with me, my lord. And my lord,
Which,
See,
what you want? Supreme Court you want to show?
my lord, paragraph, my lord. Paragraph
8, 9 and
8,
10.
9, 12 and 13, my lord.
Yes.
8, my lord,
Yeah, that is submission. Show us the finding.
My lord, here, as per this, my lord,
Please show us the finding.
my lord, after this, my lord, they have extinguished my right, thereafter they have initiated the PP Act. This thing happened in this matter. That's why I'm showing this one. Because 162, they have
Which
said,
page, which page? Page?
my lord, page 9 is the paragraph 8, my lord.
Hmm.
The letters in the last four lines, my lord. It has mentioned, my lord, it is coming under 141. 141 is the classification of tenants, my lord. As per the new act, my lord. Classification, in the classification of tenants also, grant has there, my lord, licensee is also there. So I'll come as per the new act, the licensee is there. And it is clearly mentioned that licensee, the differentiation of licensee, that has been gone, my lord, as per the new act. Once, 145A. I'll shoot that also, my lord, once. 145A.
Of
145 of the regulation, my lord, 1966. 141 is the process of tenant. In that also grantee is there, licensee is there.
145.
140, it's at page 24, my lord. First part.
Yes.
141, kindly be seen, classes of tenants. In this also grantees and licensees. Third is grantees, licensees. So licensees, what is the 145 says, how the license will be. Every person belonging to any of the following classes shall be called in licensee and shall have all the rights and be subject to all the liabilities conferred or imposed upon the licensee by under this regulation, namely every person who immediately before the commencement of this regulation. That means, my lord, 1926 regulation, if I am a licensee, in this also I am a licensee.
Yes.
So, my lord, this regulation.
There is no, I am not disputing your contention. You are a licensee. As per the regulation, licensee, there is no renewal clause has been inserted in the regulation.
No,
There is no such clause. You argued this point. After the deputy commissioner order which was challenged, you argued this point. Now that order has gone. That order has been, part of that order is set aside as regards restoration of possession. Other part remains. What are the two other parts? Jurisdictional error, and it is to be heard by the estate officer.
no. Again, jurisdictional error.
Yes.
Because
This is your argument, Miss Madam.
licensee, if I am a licensee, if it is accepted.
Late in the day, you cannot argue that. Yes, what do you say about that?
Since all funds that have been raised by the government sector and have been dealt in before the division bench order.
Yes. Division bench says that it is a license. And estate officer, right, there is no problem.
Notice of include.
But the estate officer has not considered the issue, nor your appellate authority has considered that a license granted under 4B2 will be in perpetuity or not. So, on the contrary, they proceeded on the basis it is a grant. Grant was for 30 years, it expired in 89. So after that you go, but it is not a grant. Once it is a license, after extinguishment of such license, how can you proceed?
For life period, for 30 years.
Grant.
Regulation.
Hmm.
There are aspects 141 to 147.
Hmm.
It deals with various aspects of the land which is allotted as a license, grant, occupancy, non-occupancy. That's the classifications of it. The 146, which they have said, that's why the division bench has said, once the life period is over, which is for a period of 30 years, then automatically land belongs to the government. And we have initiated a process under that old land tenure regulation 1990.
No, once the term expires, life period is
30
over.
years.
Huh?
30 years.
30 years. That is, had it been a grant?
License also is 30 years.
Sure.
Regulation 146.
Yes. Please place it.
Made to
any person may be
Yes,
make to any person for cultivation of coconut, coffee, rubber and other long-leaf crops and for construction of buildings and work to be used for the purpose or in connection with such cultivation to grant for land for any period not exceeding 30 years. Within an option for renewal for the right period. Not the license may kindly say in the instant case, it is long-leaf
no,
crops.
please read clause 2. Grant a license in writing, provided
Provided that the cultivation of rubber crop for long period may be specified the chief provision within the approval of the government. Grant a license in writing to a person is occupied any land such extent and for such purpose as may be prescribed. Your-
So grant a license in writing to any person to occupy any land to such extent and for such purposes as may be prescribed. Then
It is prescribed for long living crops for 30 years.
where do we get the 30 years?
The license is given under the
Please,
nineteen
please,
twenty.
you will get a chance to reply. Yes,
The writ petition, they have enforced the license. It is at page number 37. There are two page numbers, 37 and 23.
Page number 23.
license, yes.
Under section 4(1)(b)
Hmm,
of the Andaman Nicobar Islands Land Tenure Regulation 3 of 1926, license is a respect of between hectare through canals, river, marbles of the land as properly being enacted in the map, annex and colored light green direct comprising revenue plot number 160 in Calcutta and more in Bednavar of holding number tax equal to the Calcutta in Bednavar bounded as North River is issued by SVK Purvida, ex-agent State Bank of India, order with effect from 18 September 1952 for a period of 30 years. For the purpose of non-living crops subject to the general provision of said regulation and this rule under when countries stated below. Not, it is for a period of 30 years. Once the 30 years over, he himself has applied for extension of 30 years. The authority has rejected. Then the deputy commissioner passed an order under the regulation. They challenged before the writ court. Writ court has decided it that the deputy commissioner cannot do it because the property, once the 30 period is over, it automatically the land belongs to the government and the public provision has to be enforced. The provision has been because as due cause of law is not.
all right. Now, what is your answer to her argument as that license has to be in perpetuity?
Here, this question of the instant license is not in perpetuity. If this license is in perpetuity, then the like period ought to be mentioned in the license. When he has himself admitted the position that the license is a particular period of 30 years, which is himself over, he himself applied for renewal, which is not been considered by the authorities. And the issues of first writ petition, then the division bench has rightly ahead, and the division bench is categorically mentioned that you cannot go under the regulation for eviction because once the land was 30 years is over, the land belongs to the government authority. Now the government has to invoke the due process of law under the public provision. They are not challenged the division bench order, but they attain finality. They accept.
Why they will challenge the division? Challenge the division means says that treat it as a license.
Said once the period is over, then the property belongs to the government authority. Then
Show us that portion.
$47.
47.
No doubt the provision under 1966 regulation provides that a land for island to trust to the central government and in view of the definition of public laws in section 2 of the public laws act. Such land comes within the ambit thereof. The power to recover possession under the public laws act through a mechanism provided therein being no ambiguity. The recovery can be made from the unauthorized occupant defined there. The definition of an unauthorized occupant in the public laws act includes a person who was occupying the public laws on the basis of an authority or grant. Such authority has expired or determined. Which specified case of applied that the period of lease in respect of such a period is expired by effects of time, and therefore the respondent is an unauthorized occupant within the meaning of Public Laws Act. Apart from the same, however, attention is drawn in the order part in the WP number 252 of 2015 and MAT 32 of 2015, where the respondent authorities
have taken shelter under the Public Works Act for recovery of pollution from Andhra Pradesh and therefore the Deputy Commissioner is otherwise incompetent to pass an order for recovery of pollution.
Where is that? 30 years treated.
Effects of time is over, license is 30 years. And effects of time is specified under license is over. Expert, blood, again, I will be it is specific case of appellant that the period of means in respect of subject of the expired the effects of time.
Where you are reading? Page?
Page 47.
Yes. The definition on the basis of.
From bottom,
Sixth line.
sixth line from bottom.
That is the discussion of the court.
But that court has come with the finding that the Public Domain Act will be. However, we cannot concur with the finding of single bench at the moment we, next page, page number 48. Taken shelter under the public for recovery of pollution from Andhra Pradesh, therefore the District Commission is otherwise incompetent to pass an order for recovery of pollution under the 1996. He thus do not find any intermediate legality in the order of single bench in this regard. However, we cannot concur with the finding of the single bench that the moment the proceeding goes, the recovery is inevitable. The position was taken as per that on 1995. The appellant authority have already resumed the land. And are in position thereof, since the land of
No, please come to back to page 41. Read from indubitably.
since was granted under regulation 4.3 of the regulation 1930 for a period of 30 years.
Yes.
Subject to the general condition and this therein, the initial proceeding initiated with the parties with evidence that the sub license were treated as a grant under regulation 4.8 of the regulation 1950. But such contention was not.
Who did not accept, but such contention was not accepted and therefore.
Stand of the respondent at the later stage of the proceeding will also corroborate that the fact that the respondent abandoned such claim and accepted the position that it was a license granted under 4.1B and not a grant under 4.1A. But it was she all along considered the same fact. He also got abandoned that position. And this argument was so all along from the petition to the appellate authority before the honorable district judge under the public process before the revisional court also the same argument was admitted. I respect to submission was he himself was admitted the position. At this stage, you cannot admit back and say change the advertisement.
Admitted the position that it is a license, not a license for 30 years.
Not with sake of argument in Malad and taking into consideration it is a license also. That is a period of 30 years. That is a reflex of time. Once the period of 30 years over, Malad, what is the stand? If I could have been understand what she has made an argument saying that the license is perpetuity when there was no specific period was mentioned. Then we have to go for cancellation of the license on 151. Then the regulation says, then we have to initiate a process. But here, not the it is specifically for particular period of time.
All right. Yes, Miss Madam. Anything else?
Same thing, my lord, it has been repealed, 1926 Act, as per the 1926 regulations, the license is given, my lord. It was expired 1989. By the time new act has come. So as per the new act, we have to follow.
The new act, what you will follow?
It's 145A, says, my lord,
145.
A, my lord.
It will be, new act, provisions will apply. Though it was
No,
a.
my lord, new provisions will apply.
So new
145A is the license, my lord,
145,
A, my lord. 145.
it would apply, it would apply.
So every person who immediately before the commencement of this regulation was in occupation of any land in pursuance of a license granted under the provisions of the Andaman Nicobar Islands, land tenure 1926.
Shall be called as a licensee.
Licensee.
So you are a licensee of 30 years, madam.
That has to, thereafter it has to be determined.
Yes,
That
present, we are having.
cancelled. That has to be done. License has never been cancelled.
The এটা বোধহয় দুটো রাখো পরে ফেরত দিয়ে দেবে ম্যাডাম ইউ ক্যান টেক ব্যাক দি কপিজ আফটার দি অর্ডার ইজ ইয়েস নেক্সট ম্যাটার
My lord, in this matter, I am appearing for the writ petitioner, my lord. Service upon the private respondent is pending. I pray that matter you listed on Tuesday, my lord, I will file affidavit of service.
the learned advocate, why then you give the returnable date with this date?
WPA 188 of 125.
Wait for tomorrow because I have given the notice of tomorrow's date. So let
Tomorrow?
me pay on tomorrow.
Not today. Next,
Item number 11. WPA 189 of 125.
My lord, I am
madam, you can complete service by tomorrow, other again I have to give date.
Yesterday evening. So that-
Yesterday evening, it has to be 48 hours now. What is the issue about? What is the,
Standard copy certificate was rejected
uh,
because here when prior to selling of the property before.
government certificate is required. So you're challenging
The station officer.
you have sent it yesterday night.
No, but I have already personally have given it in the diary dispatch.
সেটা not today করে রাখো
Mention the date.
latest. All right, 10th, item number 10, not today. Item number 11,
Lord, I am appealing.
yes, Mr. Kumar.
My lord. My lord, here, my lord, for the purpose of starting a clinic in Port Blair, my lord, I have applied for no objection from the pollution control, my lord.
Pollution
Control.
control.
A no objection is required from the pollution control to start a clinic.
They cannot do so without the change of character of land. That is their,
That is, but it is not the case, my lord. But that is what they have made. Now, my lord, may kindly see. My lord, may kindly come to.
you are appearing, Mr. Divedi.
Yesterday evening only received the copy.
No, it was served day before yesterday. I have filed affidavit of service.
They're going to validate the petition along with the instruction. But they have instructed me for the time.
Very good.
That
The copy রাখবো বলো তো।
My lord, may only see para 18 and 19 I have said. That is not the requirement in their form itself.
Paragraph,
18 and 19, and inadvertently, my lord, that was not annexed. I have brought the copy of the said application.
you said as per 35A of the application to apply for consulting issued under the land use classification.
These are the classification, my lord. There is no requirement for having commercial. The land ought to be converted to commercial from the deputy commissioner. More so, my lord, this issue was raised by them.
No, till go a bit. Your clinic, you are trying to run it in a residential place. That is why you have,
Commercial use zone. That area is commercial use zone.
where do we find
My
that?
lord, may kindly come to the letter dated 35.
Why have you
Page
applied?
35, page 35, my lord.
Then Mr. Kumar, why did you apply for change of, you
That is in the year 2022, I have, my owner has applied. Now, my lord, may kindly come to page
35?
35,
Yes,
35.
yes, this is by the town and country planner
Planner.
received from 25 seeking land use zoning details.
Yes.
For the plot of such and such measuring eto recording in such a, for obtaining license. It is to state that the above plot under the falls under commercial.
Land use zone. This is exactly the requirement under clause 35A, para 18. Page number 10. And I have got that application document also, my lord.
So your contention is they cannot make any further query.
Sorry.
Did they say that Did they reject your prayer on that ground?
They asked me to provide the document issued by the authorities, my lord, that is the revenue authority with regard to the status of land. I am just placing it. My lord, may kindly come to page 36.
On scrutiny, it is found that you still not provided following information.
So and so information to provide detail of water body.
Not uploaded. Information to be provided details of water bodies at point 6 document.
That I have
Copy of land commercial
conversion certificate.
conversion certificate.
So my first argument is, my lord, this
The
is
conversion certificate is not required
not the first argument.
since it is already in a commercial use zone.
Absolutely, my lord. Now, second aspect, since they are denying this on this premises to several clinics, and this is for the betterment of the islanders, the deputy commissioner, who is the competent authority to issue this clinical certificate under the act, he issued a letter, my lord, to this authority. I am just placing that letter, my lord, may kindly see. This is the minutes of the meeting, my lord. This is of 29 December 2022, page 43, my lord. And my lord will find that this authority was also present in the said meeting, my lord.
This was when 29 December
December 2022. I am just placing the reason for that is, my lord, may kindly see agenda 2, page 44. This was one of the agenda, my lord. Now, my lord, it says it was to inform to the committee that some of the provisional registration application cannot be disposed of due to non-submission of no objection certificate for bio-waste. So and so, however, application has been submitted. This, I am not on that. Second part, my lord. The reasons cited for non-issuance of NOC authorization from the Pollution Control Committee was the non-commercial nature of land. It was highlighted that even though application has been submitted for land use change, their application has been pending and therefore unable to get the required NOC from the pollution control, as copy of land document is mandatory required for that. Further, it is also informed to the committee that as per the norms, the authority shall not undertake any inquiry. My lord, may kindly have a note of it. To the grant of provisional registration and shall, within a period of 10 days from the date of receipt of such application, grant to the applicants a certificate of provisional registration.
Why did your owner apply for?
It is in the year 2020.
Where is that? Where is that?
My lord, may kindly see the application which was made. That is, that application, my lord, will get. Page 42, my lord. He has applied for entire land. I have occupied a portion of this said land.
When did he apply?
He has on 27th of April 2022. My lord, since
Now this is a form A under rule 4A of what?
that is of land revenue and land reform rules.
All right. Take that instruction.
Kindly appreciate it, my lord. Seize this page. My lord, first of all, my lord, their application which I have postulated in para 18 and 19. This is the format, my lord. Unfortunately, my juniors did not annex it, my lord. Now, my lord will find here, if my lord comes to second page, my lord, what I have reduced in para 18, that is exactly what it is said, my lord, here in page 2.
Where what?
That the land use, my lord, land use classification of the site. In their application form,
What is the land you have clicked it as a commercial use zone.
commercial use zone, and the town and country planner said it
So,
is
but they had refused, saying that you have not given the land
the-
status.
no, the certificate whereby the revenue authority will treat it as a commercial land. That is not the requirement in their form.
But commercial zone is something different than commercial.
This is what they have want. This is, my lord, they cannot travel beyond the scope of their application. This is what in the application they want.
Land commercial conversion certificate.
Yes.
Your contention is commercial conversion certificate is not required in view of the declaration at page 35.
Absolutely. As per the 35 and
Right.
second, my lord, in their application, the format of the application
No,
did
this-
not warrant it, my lord.
Commercial, we have to understand this. When it is commercial use zone, what do they mean?
There are 3 zones as per the pollution control line,
Hmm.
entire India. So there are three zones, red zone, blue zone and green zone.
Huh.
A green zone, you cannot build, convert those land into the commercial, that's what my understanding, whatever I learned for the commercial land. In the orange zone, that is where it can be converted, cannot. be.
So this is in which zone?
This is in commercial zone, my lord. It might fall under the orange zone.
No,
So if, there is any further sub-classification, that even if it is a commercial,
The land has to be converted into commercial. That does not mean that land automatically converts into.
but that conversion is not required, that is what the revenue officer says.
and that is not recorded in their application also, my lord.
No, not that. They are page 35, a town and country planner
He is the competent authority to
says that we have, for obtaining land, it is to state the above plot falls under commercial land use zone.
lending.
So that is commercial land use zone, but that does not automatically make it a commercial land. It is commercial land use zone. That land can be used as a commercial, cannot be used as a commercial.
Hmm.
This is what I understand.
My lord, the
from the law.
purpose has to be seen. Why? And the deputy commissioner,
No, Mr. Kumar, you have to, it is within, according to you, it is a commercial use zone.
yes, my lord. According to the town and country planner, not according to me, my lord.
No, it may fall under commercial land use zone,
My lord.
but the land may be, say,
Non-commercial.
vastu, non-commercial. So that a formal application is to be required from
My
the
lord,
revenue
in their
department.
application form, this is what they have want. They only
I
want,
kindly appreciate the seriousness of the matter, because if this is done without insisting for conversion certificate, then it will open a floodgate.
no, my lord, my
You have
lord.
to ascertain that, or you come with that.
Let them ascertain, my lord. One more thing they have to ascertain, because in the minutes of the meeting, the deputy commissioner, who is the
That one provisional registration should not
should
insist.
not, because after he is the competent authority to see, my lord, whether the clinic is.
So let us come, if it falls under that zone, and if there is no other, we shall extend the time, you will pass the order to the. Or we can dispose of the writ petition on that count.
But
My lord, let him come with an instruction, maybe.
Acha, Mr.
They are saying that has to be there mandatory, they have to.
What?
Give commercial, conversion certificate. They have given me a short note. So they will, today, they'll give.
Now,
me-
Mr. Dwivedi, you just obtain the instruction.
Madam.
If it is commercial use zone, still do you require?
But
and
I believe there is requirement.
And if it is required, which is the clause under which?
Absolutely, my lord.
In
Absolutely.
the application form, which is that? Heard Mr. Kumar, learned advocate appearing for the petitioner, Mr. Dwivedi, learned advocate appearing for the. You are appearing with, you are appearing, তাহলে ওনাদের নাম দিয়ে দেবে। উপরে Mr. কুমারের নামও দিয়ে দেবে। Mr. Dwivedi, learned advocate appearing for the respondents, prays for an accommodation today to avail necessary instruction. Stop in view thereof, list the matter for further consideration on. When can you come, Mr. Dwivedi? Tomorrow you can come.
Monday आ जाइए तब तो ठीक से instruction देख
All right, on Monday. Come with that written instruction.
Because what my understanding is, I could also can fall under this entire zone can fall under the commercial zone.
But don't catch hold of Mr. Kumar, he is happily practicing here. Why you are doing it and why? He will have problems. You have already created problems, more problems. Yes, next.
Lordship, I am for the petition.
Yes, why you are not giving, sir? You will not give water.
Water tap, Lordship, domestic water tap connection, Lordship. I am an encroacher. I just a water tap connection. Someone is
No,
also.
Mr. Kumar is there. He
Yes.
will apply his good office.
Yes, yes.
System before properly, what is the problem? If it is not there, it can be disposed of.
Not today, all right. No, if it not if it is not being given, what is the reason for that? And if you find that it is a reason which is not sustainable, you instruct them accordingly so that.
Sir.
Yes.
Okay.
This matter, my senior is appearing for writ petition, my lord. Service not affected, my lord. Let the matter be fixed on 9th, 9th April.
The learned advocate appearing for the petitioner submits that service upon all the respondents is not complete. In view thereof, leaves the matter for further consideration on 9th. Stop. The petitioner is directed to complete service in the meantime. Next,
Deeply obliged.
I am representing a respondent, my lord.
Mr. Yes, where is Mr. Jaipal?
Yes, held up before court of second appeal. It's writ petition, separate care application.
For withdrawal.
My lord, let them withdraw but without liberty.
Why?
Because my lord, the order number 1, the order dated 13 November 2024. This honorable court has directed that the Tehsil may seal the structure.
Huh? They have challenged?
Just for that purpose, to avoiding
Pardon?
order dated 13 November 2024 may be seen, my lord.
Acha, then short password, let him come.
Yes.
Let me understand why you are saying that this order was challenged, page 65.
No, my lord, in this case, the coordinate bench has passed an order, interim order,
Page?
on, not in the writ petition, in the order of this honorable court, in the writ petition,
Oh, what?
dated 13 November
13 November 25,
24.
24.
An interim order was been passed.
Page 13 November, yes.
Para 5 may be seen, my lord.
There are 5. He was while entertaining the instance in this court directs that pursuant to the order of the SDO may seal the structure in question, but he shall not cause any demolition in the structure in question till 21st
Yes,
December.
my lord. Now it has been extended, so now the premises has been sealed. So
No.
now the premises is under seal.
Ah,
So if they withdraw just to vacate that order of seal, then
may seal.
there is no,
So pursuant to this order you have sealed.
yes, sealing is there.
No, not pursuant to this order. Pursuant to the SDO
Yes,
order.
real. Premises has been sealed.
So what was challenged in the writ petition?
That SDO's order.
Oh, so now if they withdraw,
Yes.
this interim order will go. The interim order was
To seal but not to demolish.
but the other condition will also automatically revive. It can demolish also.
Yes.
As you are submitting that
Yes.
withdrawal will lead to vacation of the interim order.
Yes, madam.
If the interim order is vacated, the SDO officer's order survives.
Yes, madam.
Now, why you are then not
Hmm.
placing the writ petition?
Yes.
Why you are trying wanting to withdraw?
Let them withdraw without liberty.
আচ্ছা যাও, ask Mr. Jopal.
My lord.
পাঁচশোবার করে রাখুন। এই যে এটা পড়ে হইল এই না
Item 15, WPA 107/23.
My lord, I am appearing for the petitioner, my lord, which is that promotion matter, my lord. Yesterday, my lord was about to pass order. I just want to appraise certain documents. My lord, that for promotion to the post of assistant engineer, DPC was conducted on 7th April 2021. Now they say that we are going to amend the recruitment rule, therefore it cannot be done.
please show us.
Yes. My lord, may kindly come to, first come to my lord page.
No, why did you challenge what was your challenge?
My challenge was that, my lord, for the purpose of my promotion, they conducted a DPC, my lord, on 7th April 2021. After conducting the DPC, they arrived to
Promotion from which post to which post?
from junior engineer E&M, electrical and mechanical, to assistant engineer E&M, my lord.
Very good.
I am having a bachelor degree in electrical and electronic.
Electrical and
Electronic.
they are different.
They are together, my lord, electrical and electrical. I'm just,
Very good.
my lord. So, my lord,
Take necessary steps for promotion of the petitioner. Senior most junior engineer. Acha, to the post of assistant engineer under giving retrospective effect.
Yes.
Baba.
why, my lord? 31st of May 2019, the post became vacant after the retirement of one assistant engineer, Saji. Process was initiated. I became eligible in 2018. Process was initiated, my lord.
Hmm.
Thereafter, my lord, it culminated on 7th of April 2021, my lord, whereby the DPC has recommended my case.
For promotion from which date?
DPC has recommended for promotion. My lord, I will go by what it's fallen from court. My lord, I say that at least it can be considered from 7th April 2021, my lord, when the DPC has recommended, my lord.
Yes.
When the DPC has recommended. After the recommendation of the DPC on 2 score, my lord, if my lord sees the, my lord, in the recommendation of the DPC, if my lord kindly come to page 59 first, my lord. I have obtained it under Right to Information Act, my lord, the entire process. My lord, may kindly see page 59.
Page 59.
My lord.
মনে হচ্ছে ট্যাগার নেই,
Manoj,
ট্যাগার শেষ হয়ে যাচ্ছে। আচ্ছা। আছে কয়েকটা দেখি। Page 59.
my
Yes.
lord. My lord, it is the process which has been adopted. There they say, my lord, because I am having the qualification of diploma in electrical and electronics, so they consider it. They say, further, the Port Blair Municipal Council has informed that similar case came up during the appointment of a junior
Port Blair Municipal Council.
my lord. Port Blair Municipal Council.
আচ্ছা। Has informed a
Similar case came during the appointment of junior engineer E&M under the council during 2017, and a writ petition number so and so was filed. However, the writ petition was dismissed by the Honorable High Court, and the candidate with qualification of degree in electrical and electronic engineering was appointed under the council as junior engineer E&M. Similarly, Abdul Jalil, he is the petitioner, my lord, is possessing degree in electrical and
So
electronic.
why was the writ petition preferred?
My lord, they are, my lord, because yesterday also I have submitted, my lord.
Informed that similar case means whose case? That is.
My lord, I am a bachelor. I am having a bachelor degree in electrical.
That I understand.
Yes.
I'm trying to understand this. PBMC has informed that similar case came up for appointment to JE.
JE. What happened, my lord? Because I
Appointment to JE.
JE in 2017, my lord. I was appointed in 2013. There also the issue was taken, since in terms of the recruitment rule, my lord, recruitment rule says.
Now, one by one, let us understand.
My lord.
This writ petition was preferred for what reason? This 2000.
This writ petition was preferred, my lord, as per the recruitment rule. The essential qualification is degree or diploma in mechanical, electrical, and automobile engineering.
Where you are.
Page 23, my lord. Page 8, my lord.
Education. This is for the post of junior engineer. Where you are working.
Yes.
Where your degree or diploma in mechanical engineer from a deco. Yes.
I was having degree in electrical and electronic But since it is equivalent, therefore I was appointed. Now, what happened, my lord, in the year
Pursuant to, when were you appointed?
2013, my lord, 2013.
Give the date.
Yes, my lord, I am just giving the date, my lord. On 7th of January 2013, my lord.
7th of January 2013.
My lord. Now,
On the
what?
basis of this
Yes, my
recruitment.
lord. Yes. Yes, my lord.
7th of January 2013 on the basis of page 23.
Absolutely, my lord.
Very good. Then
What happened, my lord? 2017, same, on the basis of the same recruitment rule, a process was initiated for appointment of junior engineer.
another post.
For the post of junior engineer, there the issue went to High Court. One of the incumbent challenged it.
Challenge the recruitment rule.
Challenged the appointment of an incumbent who was having the same degree as I was having, electrical and electronic.
Challenged appointment of junior of a junior engineer similar to you.
Yes, similar qualification.
Similar qualification.
Yes, my lord.
Achha, then
When they have he challenged it before the court. The Andaman Nicobar administration obtained the expert opinion, my lord, as to whether it can be treated at par or not.
Achha.
Now, my lord, the administration has accorded clearance, my lord.
Page
Page 28 and 29, my lord.
Mhm.
28 is the opinion given by the Dr. B.R. Ambedkar Government Polytechnic.
where do we find that? Now, who got administration sought for this?
Once a writ petition was filed by an yes.
Where it is said that it is equivalent?
My lord. My lord, we find from the first paragraph, it says the electrical and electronic engineer course offered to Government Engineering College Thrissur under so and so, subject having so and so, as such as passed all the engineering college of electrical engineering used to have some component of electronic engineering, and in last few years due to the marketing requirement so and so. The principal of Engineering College Thrissur has also given a certificate stating that all the university in Kerala, including the Calicut University, now awarded the bachelor degree in electrical and electronic engineering in place of bachelor degree of engineering. Hence, this is the only change of nomenclature. Got it, Malay? Thereafter, they say, in view of the above, students having degree in electrical and electronic engineering can be considered for appearing in the selection process mean for electrical engineering of your department. This was on the basis of the certificate issued by the college at Kerala.
On the process meant for electrical engineers.
Electrical engineer of your department. This was with regard to APWD, my lord. But this opinion was sought whether the electrical and electronic degree can be considered as a degree in electrical and mechanical, because E&M is the post, my lord. So the administration say, the Polytechnic, the Dr. Ambedkar Polytechnic said, yes, it can be done. Thereafter, administration also given their opinion, my lord, at page 29.
So their contention was mechanical stroke electrical is not identical to electrical and electronic.
Their contention, yes, my lord.
So that was clarified and said that electrical and electronic will be entitled.
Yes, entitled, my lord.
Now the
second opinion was given by the administration itself. This is by an expert body of the administration.
Achha, what do they say?
They say, my lord, in this, they say, my
In
lord,
this connection,
I am to direct
please read. I am directed seeking clarification for inclusion of candidate possessing degree for appointment with JEEM in APW. APDW.
The post is same, junior engineer E&M. Here also, my lord, the post is same. Page number 23. Same.
And
So-
the matter has been examined, viewed expertness and found degree or diploma electrical. Similar, thus there is no valid reason. Very good. Then after this, the
After this, that petitioner was already appointed, page 59.
what was the name of that person?
My lord, that.
Very good. The person was appointed, which petition was
Dismissed, my lord. The petition was dismissed because he did not pursue. That order also I have enclosed, my lord, in this.
Where is that?
My lord. My lord, may kindly come to page 133.
One 33.
Sorry, my lord. No, this was the initial order. Thereafter, perhaps it was dismissed, my lord.
Very good. Then what happened?
Then, my lord, while considering my promotion at page 59, now, my lord, may kindly see page 59.
You were you are Abdul Jalil.
Abdul Jalil, ma'am.
Here it is. Binoy, who was Binoy Kumar?
He is junior to me.
Here it is. Junior did not raise any objection during appointment of Jalil or publication which claim Jalil, he raised this matter only when
He was appointed along with me, my lord, and he was junior to me.
he was junior.
Yes,
So he raised an objection
yes, my lord.
initially.
Yes, at the time of consideration.
Promotion was considered to be as per seniority, senior was and fulfills criteria. Very good.
Now, my lord, may kindly come to page 80, my lord.
Page 80.
My lord, 80, my lord. This is all under RTI, my lord. I have obtained the process, my lord.
Mr. Divedi did not give it to you. You have to go for RTI.
We have annexed those, my lord. In our opposition, we have annexed everything.
Yes.
My lord, page 80, it says, second paragraph, based on the proposal received from Port Blair Municipal Council, by letter dated so and so, a meeting of DPC was held on 7th April 2021 at 10:30 AM in the chamber of Secretary UD.
No, where is this 20th January 21 letter? Based on the proposal received from. Now, what is the date of the DPC? You said it is
7th April, my lord. It reflects from,
7th April.
yes, it is there in paragraph
17th.
7th April 2021, my lord.
You're sure?
But it is there, my lord.
Page 59.
80, my lord.
No, this page 59 DPC is of which date? 7th April 2021. Page 59 is
My lord,
good,
my
na?
lord, my lord, my lord.
That is the DPC you said.
No, that is not the DPC. I just replaced the document from RTI. First, I want to clarify this position to my lords. That this is the way they have considered first, because there was an objection and this was there. Thereafter, my lord, at page 80, I said, my lord, this is the date which is given in page 80. If my lord sees second paragraph.
Where is the date given?
My lord, third line of second paragraph, my lord. It says, based on the proposal received from the Port Blair Municipal Council dated so and so, a meeting of DPC was held on 7th April 2021 at 10:30 in the chamber of so and so.
Then what is page 59?
Page 59 was the consideration when the files was mooted, whether my case can be.
This was departments.
Because, my lord, an objection was raised. And they have clarified this first, whether my case could be considered or not.
Then based on the proposal received, a meeting of DPC held on 7th April,
Yes.
chamber,
Yes.
council filling up of one poster.
Assistant engineer, the minutes of the meeting is placed. The DPC was informed that one post of assistant engineer carrying the scale of pay so and so has fallen vacant under the council, consequent on superannuation retirement of Saji George, assistant engineer on 31st of May 2019. I have set the date, my lord. 2019, as per the recruitment rule, 4 posts of assistant engineer E&M exist and one more was created by order dated so and so, making the total strength of assistant engineer 5. As per the notified recruitment rule dated 21st of May 2012, the assistant engineer, the provision therein prescribed for the above post is given below. Now, my lord, may kindly see this. Just skip it, my lord. That is the provision of the recruitment rule. Thereafter, it says the seniority list of junior engineer working under the council is mentioned below. My lord will find that my name is at the top, my lord. Abdul Jalil, my lord, serial number 1. Now, next page, my lord will find the committee noted that Sri Jalil holds the degree in electrical and electronic engineering instead of mechanical, electrical, automobile as laid down in the recruitment rule for the post of assistant engineer. However, the committee is of the view that the degree in electrical and electronic engineering can be constituted as equivalent as mentioned in the RR. Because in RR, my lord, it is specifically in assistant engineer's RR, it said equivalent word is also there, my lord. In junior engineer, there is no word of equivalent, my lord. But in assistant engineer, there is the word equivalent is there at page of 24. Clause 12, my lord.
Oh, in the junior engineer, that is not.
That is not there. But in assistant engineer, that is there. My lord, most of the cases where promotion posts are there this qualification is not required, my lord, when 100% promotion. Because the incumbent in feudal post, once he fulfill the qualification, then only he is appointed.
But yes, then
my lord, page 81.
yes, DPC after going through background.
Yes.
Other recommends promotion of Jalil in the post of Ato.
Yes.
So everything was done.
Everything was done, my lord. No, my lord, may kindly see their reply, my lord, once.
Now this where is that police verification and
Yes, my lord, it is there, my lord, at third paragraph, page 81. Hence, the DPC, after going through the background note, recruitment rule, vigilance clearance, integrity certificate, and other relevant document. Got it, my lord? Page 81, my lord. Second paragraph. Hence, the DPC.
yes.
Hence, the DPC, after going through the background note,
Vigilance
clearance, integrity certificate, and other relevant records, recommend for the promotion in respect of Abdul Jalil to the post of assistant engineer on regular basis under Fort Blair Municipal Council.
Very good.
Now, my lord, their contention is that, my lord. Now, my lord, may kindly see their reply once, my lord. Opposition, my lord.
Position page.
Page 3, my lord.
Yes.
My lord, 5 subclause A, my lord. They said during the year 2019, council started the procedure to fill up one promotional post which has become vacant on superannuation of so-and-so. The council-wide letter dated as requested to conduct DPC for promotion of AE copy of the so-and-so. Initial application was made by the council on 13th of August 2019, my lord, immediately after the retirement of the incumbent. Now, my lord, may kindly come to clause F, my lord. Page 5. It says, with reference to the Deputy Secretary letter dated 18th March 2021, DPC to fill up the post of AE was conducted on 5/4/2021. Here, my lord, the date, I think they are wrongly written for 5th April. I don't know that was 7th April 2021. We have seen
7th April.
Yes, but here it is 5th April it is written.
But they have annexed R7.
R7.
Is it the same document?
My lord, the copy which they give to us, there is. No, my lord, this is 18th March 2021. Here also the date
Is 18th March 2020.
and it was fixed on 5th April, my lord. Perhaps that day it was not done and 7th it was done, my lord. Now they say that, and the recommendation of the DPC was sent to the Honorable Lieutenant Governor. My lord, may kindly see page 5, para F. Fill up the promotional post of so-and-so was conducted on so-and-so under the chairman, and the recommendation of the DPC was sent to the Honorable Lieutenant Governor. Now, my lord, may kindly see the reason. Page 6, para J. In the meanwhile, amendment of recruitment rule for the post of AE, JE, E and M was proposed by so and so, the copy of the proposal is annexed.
What was the proposal?
Yes, my lord. Page 58, my lord.
So this amendment in the recruitment was proposed.
Proposed in 2022.
Why amendment?
My lord, amendment was recommended that degree holder will get 50%, diploma holder will get 50%
Of the vacancy.
of the vacancy, promotion.
But you are a degree holder.
I am a degree holder. Now, my lord, this was done after a year from the proposal made. Now, this is not yet amended, my lord. Now, what I am, my lord, I am eligible in 2018. 31st May 2019, post was vacated. PBMC, Port Blair Municipal Council was not at fault. They themselves say that on 31st of August 2019, Port Blair Municipal Council has mooted the file for promotion. My lord will get a clause. Page 3, 5A. The date is also given. From 2019, my lord, it took more than near.
Then ultimately, what do they say?
Then, so this
When
is
this amendment was proposed.
proposed. This is the reason now they are saying that we will not do it.
No, we have not said that we not do it. But may kindly now come to page 5 of my opposition, para F, my lord.
Paragraph I have
Yes.
shown, my lords.
But with reference to the just placing with reference to the deputy secretary letter dated 18 March 2021, DPC to fill up the promotional post A under PBNC was conducted on 5/4/2021 at 3:30 PM under the chairmanship of Secretary UD, and the recommendation of DPC was sent to the Honorable Lieutenant Governor. This is a process, Mala, which they have to send it to Lieutenant Governor. Number para G, the Deputy Secretary UT with a letter dated such and such informed that on perusal of the proposal for filling up one post of Assistant Engineer, the HLG, the Lieutenant Governor has raised certain observations since requested to attend those observations. Until those observations are been attended, but the final signatures of LG will not be done, will not be promoted. Now thereafter, because those are the process,
My lord, it's an automatic.
these are the process, my lord. It has to go from the under secretary UD, thereafter the law department, thereafter the LG. Finally, LG will give us.
That is for what? That
For promotion only.
HLJ has raised certain observations.
So we have raised certain observations. Those observations are being sent to secretary under development to the PBMC. PBMC made those observations, my lord. Next, but according to the clarification has been sent to the administration, para H, my lord, sent to the administration with a council's letter dated such and such. Number thereafter, para I, thereafter a proposal to fill up one vacant post of A was sent to the administration for conducting the DPC with the e-filing number 24751. Next page number 6. In the meantime, amendment of recruitment rule for post of A was proposed.
This clause I, fresh proposal for DPC, why required? It has been already.
Because for those observations of LG have been met with, the answers have been given by the certain. LG might have raised some question or there.
That is there, annexure P8. What was the observation? P8 is at page 27. LG has raised certain observations are not here.
Observations are not here, madam.
So very good. The observations were replied to by
the council. And madam, thereafter it has been sent. Now thereafter when it has been sent, in the meantime, madam, page number 6, para J, madam. In the meantime, amendment of recruitment rule for the post of A was proposed with a e-filing number such as to the administration further.
No, I am not understanding that DPC was held on 7th April 21. Then after that, Deputy Secretary informed that a perusal of SEL the governor has raised some objections. So the observations were replied. Now again, now you are saying that it has to thereafter fresh proposal to fill out same way for conducting DPC.
No, actually, it might
You
be
only
like
need two DPC. Once DPC was held,
my lord.
then what is the requirement for another DPC?
No, because as per the LG, it was not a complete process. There are some gaps are there. That's why, my lord, this DPC. We are not saying we're not going to make him promote or something like that. Only after that we see page number 6, my lord, para case, the law department has said you first do this recruitment and then you process with it. That's the only hurdle, my lord. That is the only hurdle. Para 6, my lord.
Then it is further.
Page 6 para it is pertinent to mention that on 16/10/2023, the Honorable High Court Circuit Bench has passed order dated such and such in repetition such and such for this is for recruitment, my lord. Initially, there was
This has nothing to do with the assistant engineer promotion. Clause K.
My lord,
That is for junior engineer.
This has nothing to do. That is also from my understanding, but since the law department.
This is for which post? Passed an order, Sri James.
This is only for recruitment, Mala, recruitment of the rules. It has to do with both JE and AE, but it is for the amendment of recruitment only.
No, there is an order passed. Any promotion of authority in respect of assistant shall abide by the result of the amendment. How can this be said?
That is from the law department's observation. Interdepartment.
No, this is a writ petition order.
No,
Yes, my lord, writ petition order.
So any promotion, that writ petition, this Stanley is your
junior.
So
He is a diploma holder. He want amendment. He say, my lord, that the requisite length of service for diploma holder ought to be curtailed down.
So in that you have not been made a party?
No, he was not a party.
So in that it was said any promotion made will abide by the alleged, by the result of the alleged amendment of the recruit. How can this be done? Promotion is made today. Tomorrow amendment, it will have retrospective effect.
Or from this order, my lord has made us this. He should have actually challenged that order or intervene in that order.
Oh, you should have done so.
We have not challenged this or not challenged. We have asked for modification in fact in the order. Court said, okay, you don't do it in 4 weeks. You do in a considerable period of time. So it's going on. They are doing so.
In that writ petition.
In that where we have made for modification of this order.
Modification.
I think appeal only. We have filed appeal only from this order.
Why? Because that is stalling the process of promotion.
No, because it said that you complete it within 4 weeks. It's not possible to complete the recruitment, do the recruitment, amend the entire recruitment rules in 4 weeks.
Mr. Dwivedi, for what reason his promotion will be upheld?
Because of this also, any promotion of the authority in respect of the assistant shall be abided by the result of the alleged amendment of the. Now, my lord, I am.
So promotion given will abide by. He is naturally.
That your lordship, my lord, it will fall for your. This is only my submission. Now,
but Mr. Dwivedi, now again a DPC has to be conducted.
No, that has been conducted only.
That play, you have showed me clause.
They have given the replies to the LG. Now they are just not forwarding it to the LG because for this amendment. So once they will forward it to the LG.
No. Clause I, page 5.
My lord.
Thereafter, a fresh proposal was sent to administration for conducting DPC. Why? This must not be relevant to his case.
My lord, or otherwise they might have chosen wrong word, Malar. It must not be fresh. It must be with those of the reply to the observations of the LG.
Where is that R10? Proposal promotion of assistant, although recruitment is under process, however, as shown, seniority doesn't get affected. may be initiated. Now there are 5 sanctions.
But in R10, if I show, if the lordship may kindly come to page numbers, 53.
Practically on wrong factual matters.
But even if amendment is made, Mr. Dwivedi, it cannot be retrospective, na?
Mal,
How he will be affected by this?
My lord, page 50, my lord, it's very clear, my lord, page 50.
Just a moment. Page 50.
My lord, their own document,
Yes.
they have even relied upon, my lord, the OM, which I am holding with me. I have already served the copy. My lord, the promotion ought to be made in terms of the recruitment rule, which is in existence. That already I have served this to my learned friend. My lord, they also refer to it. And my lord, may kindly see.
Where?
Page 49, my lord. My lord, may kindly have a look to this poem, my lord. This is of 10th of April, 1989.
No, page 50, what you are showing.
Yes, my lord. Page 50, I was showing, my lord. They themselves, after referring the OM, this OM, they say, in view of the above narrated fact, it is to inform that as per the recruitment rule in force, the eligibility criteria mentioned in the proposed RR does not affect the candidate of serial number 1 and 2. I am at serial number 1. Since the DPC for the post of A is pending, it is suggested, because DPC was conducted, they wrongly used the word pending. Further, my lord, may kindly see. It is suggested, if approval, we may forward the file to the law department under so and so for obtaining legal opinion, suggestion for conducting.
For conduct.
Already, there is no scope, my lord. Once my lord, DPC was conducted. Now, my lord, may kindly see that OM, my lord. Office memorandum. 3.1. I have just enclosed the relevant extract, my lord. 3.1. I am just reading. The DPC should be conveyed at regular annual interval to draw panels which could be utilized on making promotion against the vacancy occurred during the course of a year. For this purpose, it is essential for the concerned appointing authority to initiate action to fill up the existence as well as anticipated vacancy well in advance of the expiry of the previous panel by collecting relevant document like CR, integrity certificate, seniority list, etc. for placing before the DPC. DPC could be conveyed every year if necessary on a fixed date, 1st April or May. The ministry department should lay down a time schedule for holding DPC.
Why you are reading this?
Because, my lord, last 6 line. Vacancy, got it, my lord, shall be filled in accordance with the recruitment rule in force on the date of vacancy unless rules made subsequently has been expressly given retrospective effect. Now, what I am on, my lord, already there exists a recruitment rule. On the basis of that, a DPC was conducted. You have to give effect to fill up the said post which was vacated.
But they are now saying a fresh DPC has to be done.
My lord, there is no fresh DPC after the recruitment rule is amended.
Where do you get them?
My lord, this is what they say, my lord, in para I and H, my lord, in the mean, their contention was that.
Madam, page 50, they kindly come to page 50. This is the law department's observation after PBMC sent in view of those memorandums in their comments.
Page 53.
Page 53, my lord. This law department, after they sent PBMC sent it to the law department, my law department said that in view of the above, para number 4, in view of the above, it will be appropriate for the department to amend or modify the recruitment rules, which is under process as on date, with the approval of competent authority and to notify the same in the official gazette. It may be noted here that the time limit granted by the Honorable Court has already expired. Department concerned is requested to take the speedy steps to avoid any complication or content in the matter. Thereafter, the DPC may be conducted in terms of notified recruitment rules by adopting due process and with the approval of the competent authority. So here, all the hindrances are created by, I must not say, but created by the law department.
Now this issue, then I have to be silent as regards DPC, na? If the DPC is to be conducted afresh upon amendment, then his DPC goes, which was under the unamended recruitment rules.
No, personally, I can't
If
see here in this letter, they have said that where they have to conduct.
They have said that in page 50. For since the DPC for AEAM is pending, it is not pending. It is suggested, if approved, we may forward the file to the law department for conducting, obtain suggestions for conducting DPC. And let's see this, if DPC is now has to be done, then the entire process gets stalled.
And my lord, page 53, they say, my lord, DPC will be conducted after the amendment.
Page 53.
53, last paragraph. 53, my lord, thereafter, they say first amendment. My lord,
As per the direction of law department, we may forward.
The last line, my lord, may kindly see. My lord, my learned friend has read rightly that in view of the above, the department may amend, modify the RR. Now, my lord, may kindly see. Thereafter, the DPC may be conducted in terms of the notified recruitment rule by adopting. So this will not come into play so far as my case is concerned. This DPC is pertaining to the amendment which will be carried, and thereafter they will conduct an DPC.
And my simplest thing, I can only suggest subject to correction of your lordship. If
we shall explain that.
Yes.
And your contention is that writ petition is pending, in which he is not a party.
Not a party.
So we will clarify, since by that order it has not been said that you cannot fill up the
Yes,
post.
yes, ma'am.
If the post is filled up, it will abide by
That will not do the name.
But you will be in problem even that is done, because that division, that single bench has said will abide by the promotion made, come to that order.
Yes, my lord. My learned friend has.
Yeah.
Will abide by the amended recruitment rules.
It is absolutely.
This is against you. Because if you get promotion under the previous rules, if the new rules comes and if the amendment is done altering the qualification, then your right to the post goes, no?
No, the amendment is not with regard to. The amendment is only regard to he was a diploma holder. He said the requisite length of the service ought to be curtailed down to 9 years. That is the writ petition, my lord. My learned friend up here, he can better appraise, my lord.
It's only regarding the qualification, not a.
He was a diploma holder.
So that is Stanley.
Stanley was a diploma holder.
Stanley is a diploma holder, and he said that the period must be
requisite length of the service.
What was the period required?
My lord, for the degree holder, it was.
Recruitment rules were from the degree holder, page 24.
9 years, my lord. My lord, page 24.
Yes. Where you are getting 9 years?
My lord, clause 12, promotion from amongst the serving regular junior engineer E&M of the council in the scale of with 5 years, oblique 9 years, regular service in the grade.
Why oblique?
Because 5 years for degree, my lord will get in second line. Degree 5 years, diploma 9 years. So he approached the court saying that instead of 9 years, it ought to be curtailed down to 7 years forever. Yes, so it is altogether, and my lord, kindly have a note of this office memorandum, my lord, which clearly says this office memorandum of 10th April 1989.
Prospective.
My lord, 3.1 last 4 line. It categorically says a vacancy shall be filled in accordance with the recruitment rule in force on the date of vacancy. So I am on that, my lord. Now, my lord, my last submission would be on 21st of April 2021. The DPC was conducted.
That's how we done.
Fault, my lord. Kindly see. And I am today this.
But you did not work as a promoted.
No. On-site fire.
And they will say we have not given the, be satisfied with this. We will say you will get promotion within your stipulated period.
My lord,
That's the order coming back.
my lord.
Well,
Yes, Mr. Jaipal, why you are claiming withdrawal with leave to file a,
don't want leave.
you don't want leave?
No, prayer has been made in this application for liberty to file afresh. No such leave is required. Simplicity withdrawal of the application.
But in the withdrawal application, you said that it will be,
I will not, my submission can, my client is very much present, it can be recorded, not is very much present.
that's why you are withdrawing?
My administration have assured my client, you
That-
have filed it, you got an interim order.
Ah.
You get the writ withdraw, we can do something, we can revisit the entire issue. I convinced my client, that can be an order of the court. No, sir, let's withdraw it, because they are willing to do the.
আচ্ছা ওই প্রথম ফাইলটা দাও you are who is Mr. Kumar, Mr. Neo Shiva, is he there?
His presence is necessary.
আচ্ছা ঠিক
Short pass also. I'm calling.
I come back after half an hour.
My lord.
এটা এখন অর্ডার দেবো
Also, next matter is 16 by matter, by one of near relative expired, so I have to go there.
I do not dismiss for non-appearance. I did not dismiss, I keep it on that date. I request the advocates to do it so that we can finish up the matter. Anyway, if you are in bereavement, you may leave. Which is your matter?
Next 16 number.
Who is your other side? When do you want it?
One day.
চলো মানডে করে দিও ওটা আইটেম নাম্বার 16 মানডে চলো
In this case, Ms. Snap is appearing on behalf of the respondent number for BSNL, my lord. Ms. Snap, senior advocate is appearing on behalf of the respondent BSNL, my lord. So related
Where
to.
is she? Where is she?
Due to some personal difficulty, she just left the court, my lord.
No, we told yesterday only that we will take.
Instruction.
Oh, you had to take instruction. But what was Mr. Jaipal? It was
My
really.
client was terminated on the ground that she suppressed the.
Acha, the criminal case.
Proceeding. Now she was terminated. I'm still working by way of.
Yes, yes, she asked that I will take this. Very good, come tomorrow then. Tomorrow it will be available?
Yes, my lord, definitely.
Yes.
Okay.
Which is that matter, Mr. Where is that? That person has retired already?
I was not. Yesterday, I have issued a notice also, my lord.
That you are the petitioner?
No, I am for the private respondent, my lord. I am the sufferer. I am from service, my lord. I was not there when it was mentioned, my lord.
I also, it did not strike me, otherwise I could have. What did I do?
My lord has, I have been told that my lord is Monday, my lord.
A Monday
Monday,
topic করে দাও। Yes, yes. কত নম্বর আইটেম? তো 16টা তুমি ওই মানডে টপে করে দেবে, হ্যাঁ, হিয়ারিং এর। Yes, any other matter?
Yes,
Both sides? Yes.
I am appearing for the petition, my lord. There are, my lord, there are two matters, both are entirely different, but that has been tagged, my lord. So I am going to argue in my matter, my lord.
You are for the other. You are for in item number 18.
Yes.
18.
You have a formidable opponent, Mr. Kumar.
My lord, here, my prayer in this application is very
Now,
low.
she argued one matter before me.
My lord.
She was very strong on the issue.
Yes, my lord.
Good, you must have that zeal. Even if your matter is bad, you must have that zeal. Yes, tell us what is the problem
My
here.
lord, the issue is, my lord, my father has gifted me some land. There were other brothers and all. My lord, there was always an issue with regard to the property. My father has gifted 150 square meter, but it ought to be 200 square meter. There was certain dispute, and ultimately, my lord, when the matter was pending before the subdivisional officer, being the statutory authority, my lord, a settlement was arrived between the parties. Whereby my father, in clear terms, in the settlement, said that 50 square meter will be paid to me, will be given to me, and rest of the land would be given to my brother, 25
So
square meter.
you are Sulata.
Sulata, my lord.
Very soon.
This settlement was arrived. After arriving this settlement, my lord, the appeal was disposed by the subdivisional officer. Whereby the subdivisional officer directed the Tahsildar to demarcate the land
Very good.
while disposing, my lord.
In presence of the heirs.
All the parties. Demarcation was held, my lord. Demarcation was held. After the demarcation, I have been given those 50 square meter. Possession was handed over. Now, after the possession was handed over, my lord, there is a report of Tahsildar which says, my lord, that in terms of the order of the subdivisional officer, the demarcation of the land was conducted and the following field finding are mentioned below. And thereafter, it was said an area of 50 square meter, which is to be registered in favor of my client. This has been mutually agreed by the parties. Thereafter, it says in this connection, the application along with field report is hereby sent to settlement wing for further action, please. Now, my lord, this further action was not taken by the settlement wing till date. One of my prayer is.
What is the further action? Recording of name.
Yes, recording of name. That has not been done. This is my first. Second, my lord, after this, because this was in 2015, my lord, this order was passed. After this, my lord, several years passed, my father also succumbed to death. The writ petitioner in other case, they are my brother and sister. And there was frequent quarrel and all, my lord. Now the property is subdivided in different wing. I made a representation before the Tahsildar in 2021 saying that to once again redemarcate, because now the land area has been enhanced, my lord. My area was enhanced to 200 square meter.
No, that 50 gift was not accepted by them.
Which
your father agreed to give.
No, that is not the subject matter at all in any of the.
Then what is the subject matter now?
Here, my lord, first this has to be done.
What has to be done?
This, my lord, page 41.
That is as per the settlement, no?
The settlement before the statutory authority, and the statutory authority directed. My lord, may kindly come to page 41 once, my lord.
Yes.
This is the report, my lord, on the basis of the order passed by the authority.
Where is that SD order?
SD order, my lord, may kindly come to
Which records the settlement?
page 37, my lord, and the settlement is at page 35. All
No, 37 refers to the settlement, na?
yes, my lord. And settlement, I have also enclosed page 35.
Very good.
Hmm.
What is the settlement? Settlement minutes, very good. Now 35, it was said, case disposed of, directed to demarcate. Now page,
My lord, my lord will find that my other side, they filed a writ petition, their signature is also there in page 36, settlement.
very good. Next page 41.
Page 37, my lord.
37 is the SD order.
SD order.
Now demarcation,
Demarcation was held, my lord. All those reports I have enclosed, page 38, 39.
now what is 41?
41 is the, after the demarcation, the order of the Tahsildar, my lord. It says report, furnished demarcation report, that in terms of the order of the subdivisional officer, the demarcation of land has been conducted and the following field finding are mentioned below. An area of 50 square meter belong to so-and-so, which is to be registered in favor of so-and-so is shown in red. An area of 20 square meter belongs to NS group are to be registered in favor of so-and-so. This has been mutually agreed by the parties. In this connection, the application along with field report is hereby sent to settlement wing for further action. My grievances is that the Tahsildar has sent it to the settlement wing for taking further necessary action. No action was taken by the settlement wing. This is one prayer, my lord. Second, my lord, I say, my lord, by the passage of time, after the same, this area 150 has become 200 and my brother has got 130 to 150. Now, my lord, once again, there were several issues between the parties. Civil case is also pending. I filed an application on 16th of July 2021, page 43, saying that to conduct a re-demarcation so that the allocation could be properly identified. That is pending. These are
But that demarcation which has already been made, that is in terms of the settlement.
that in terms of the settlement.
So if the settlement has taken, in terms of settlement, demarcation has been done.
My lord.
Now why re-demarcation?
Because, my lord, after this, my lord, once the area has been enacted.
You want that the,
Demarcation of,
no, to the settlement wing for further action. Action will be only for recording the quantum of land in respective shares.
yes,
You are saying that this has not been
this
done.
has not been done.
So now if you insist for a fresh demarcation, this stage goes.
My lord, I will not insist. I will only confine my argument to page 41.
41, you say that the screening settlement has not yet been done.
Yes.
Then which page you are showing me that you went to the Tahsildar again for demarcation?
That, my lord, at
Page 43.
43, my lord.
So now you preferred the writ petition for consideration of this.
No, for this page 41. First
41.
prayer is page 41, my lord. That
Now what is
settlement.
42 vacation order?
That, my lord, what happened in the meanwhile, though it is relevant in the other case, which was filed by my learned friend, there, my lord, my father died, my lord. After my father died, they took out a will saying
Father died when?
father died on
2022. March 2022. March 2022.
Second August 2020. So what is this vacation order? It is a stay order has been
what
obtained.
happened, my lord, after the father died, they took out a will and say that on the basis of the will, they enjoy, so far as this dispute is pertaining to fathers, because after after executing a gift in my favor, father still retained 444 square meter in his name.
I see.
So they say that under the dint of that will, that area was given to them. That I have challenged in a civil proceeding before the civil court. In the meanwhile, they obtain a vacation, the stay
So
order
that 444 now,
remains with the, in the name of father.
so that demarcation was made in the 2015 in terms of the settlement.
That is the only issue, my lord. My client says this demarcation was pertaining to my land. If my lord sees the demarcation report also, this is page 39. It is pertaining to
Only that 50 square meter.
50 and 25. 50 and
With regard to 47.
50 and
It is at
20
page
square meter.
38.
20 square meter.
Report is at page 38.
38. Demarcation conducted, shown all sides. So, yes, what you are saying?
No, my lord was asking, my lord, why this vacation order? His
Hmm.
father died, they obtained an order from Tahsildar on the allegation that certain construction is carried out. Then carried out in my land, but they say that it was in the land of father and all. Thereafter, this is the vacation order. That
Stay was granted, then vacated.
and interim stay was granted by the Tahsildar.
Acha.
That was vacated thereafter, my lord. Thereafter, again they have obtained a stay. Thereafter, they
How can this be resolved? What order do you want from the
no,
court?
my lord. So far as this issue is concerned, this vacation and stay, that was
This is of 2015.
444. That is 444 survey number. That issue, my lord, which is the issue. Stay order and all is confined to the area. Which
In
is
another survey number.
Yes, survey number, one survey number, 639/1 recorded in the name of my father.
Then this settlement was in respect of which survey number?
639/1 by, my lord. My lord may kindly see this settlement. My lord may kindly see page 40, everything would be clear. Page 40.
Yes.
My lord will find 639/1, 444 square meter. This is in the name of father. Today also it is in the name of father.
Where do you find 444? 69, yes.
Yes, this is in the name of father.
Very good.
Here they are claiming their right under the dint of a will.
Acha, very good.
My lord, here Sulata, if my lord sees serial number 3, this is 150 square meter already have been given under the dint of a sale deed and plus 50, my lord, for which this was done.
Plus 50, where do you get?
Yeah, my lord,
This is a.
lastly it is written 200.
200. That 50 which was gifted.
Gifted. Total 120 I have, 200 I have got, and my father land is also reduced into 374. 444 was reduced into 374.
Because 20 was given to another.
Yes. So, my lord, now so far as the other writ petition comes, that is with regard to my father's land. This is with regard to the settlement which has been arrived and
Pertaining to survey number 639 by 1 by 1, 1 by 2 and 1 by 3. Who is this Kurup? Kurup is the father.
father.
Very good.
So now, my lord,
Now the problem with them is your dispute is in respect of 439.
there is no dispute.
No, in respect of 439 1 by 1.
1 by 1. That is the dispute in this.
What is the quantum of this 430? Oh, that was 444.
It's reduced into 370.
Very good. Now, what do you want from us?
In this case, I want page 41. My contention is that there is a order by a statutory authority whereby settlement was arrived.
So implement this.
Implement this. This is the
For 7 years.
My lord, that is there, my lord. I cannot travel beyond the scope of the what is there, that is there, my lord. But this is an order passed by a statutory authority in a statutory.
I will ask the subject to what they say. I will ask the Tehsildar. Now, who will this settlement wing means who is the
Under
officer?
the deputy commissioner, my lord.
That cannot be done.
Let me understand.
Respondent number 2, my lord.
Who is that?
Assistant Commissioner, Mr. Siva Balani, sir.
No, that is not the case. As per the settlement,
As now, yes, you now you tell me what is your job.
as per the settlement, they will get certain 50 square meter, 20 square meter. But that the Mr. Kurup has to execute a common gift deed, registered has to be done before the sub-registrar. That has not been done. Kindly see page number 35, last paragraph.
Then how did your SDO accept such settlement?
No, only here.
You are not running away. I will be here.
Kindly see page number 35, my lord.
Yes.
Last paragraph. After the settlement, it is further agreed upon that Srimati Sulata as well as Sanatana group shall not proceed with any further to the demarcation issue and shall withdraw the proceeding on consent. That Sri NS group shall execute a gift deed, settlement deed within a period of 1 month, and the matter will be taken up jointly before the sub-registrar. This has not been done. And the only it is recorded in the report that to be registered. To be registered means this registration has not taken place.
Where?
This 41, my learned friend has shown, my lord,
Mhm.
50 square meter out of such and such belonging to NS group, which is to be registered in favor of Sultan. Registered means he has to execute registered deed. He has to pay the stamp duty. By superseding paying this without paying the stamp duty to the government, it cannot be transferred, my lord.
This is yours.
Yes, ma'am.
Yes. Now what is yours?
Look, first, they have annexed the gift deed, madam, which was executed between the father and the Sulata.
Gift deed was
Gift deed
executed.
was executed first, or earlier, madam, it was executed.
In respect of that, in
150 square meter of land,
50 square meter.
only 150 square meter of land. Madam, kindly see first, madam, annexure P1, page 20, madam. It
Of
was
this,
executed in the year 2004. The total land was, madam, the father had total land 977, madam. 977 square meter, madam.
where do you
My
find?
In my opposition, I have written, madam. My father had.
796 square meter.
Madam,
In the deed it has been given.
thereafter it was path and all, it was that way.
So
Earlier
150 was gifted. That was the gift deed.
gifted.
Hmm.
Madam, now kindly come to the settlement.
Yes.
Annexure P3, 35 million. May I read once, madam? Today, it's at page 35, madam.
Hmm.
Today, that is 6/10/2012, all the parties as stated above, present in presence of their respective councils, Tapan Kumar Das and Roshan George, had a thorough discussion about the demarcation of the land situated at AR Road, Diglanipur, Chandigarh village, being survey number 639. The main issues pertain to the access road to their respective plot. So the main issue was the access road to their respective plot. This was the issue. The controversy between the parties continued in various proceedings, and there are two such proceedings pending before the subdivisional officer, South Annam and Secretariat Court by Municipal Council. There were two proceedings were pending. Thereafter, my lord, it is agreed between the parties that the shortfall of the land of Srimati S. Sulata shall be compensated by registering a gift deed to the extent of 50 square meter of land exactly behind the plot number 639/1/3. Here, my lord, I am pausing because that the shortfall of land of Srimati S. Sulata, here the petitioner, because she has been gifted 150 square meter of land. The shortfall of land of Srimati S. Sulata, if at all any shortfall is there, that it means, my lord. She was,
Shortfall of land for what purpose?
she was given with the 150 square meter of land,
Hmm.
but he was saying 150 is not there. That's why this land has come. The shortfall of land of Srimati S. Sulata shall be compensated by registering a gift deed to the extent of 50 square meter land exactly behind the 639/1/3, which was gifted already and which was already subdivided mutually. Now, my lord, again in the last line it is there, my lord. It has to be done. When it will be done, my lord? That Sri NS Group shall execute the gift deed or settlement deed within a period of 1 month, and the matter will be taken up jointly before the sub-registrar. So this was done on 6/10/2012. So the any gift deed or the settlement deed has to be executed within a period of 1 month. That is also mentioned, my lord, in the settlement deed. If at all any shortfall of land is there to this Sulata.
No, where from the shortfall comes? Shortfall for what?
My lord, the gifted land is only 150 square meters
Yes.
land.
Yes.
Now she has stated before the authority, but
where do we get that?
my lord, actually the main issue was access road. That was the issue before the SDO. That was before the SDO. Thereafter, there was some settlement that 150 was given to the Sulata. If at all any shortfall is there, we will give.
Then what is recorded in page 37?
Now, my lord, kindly come to the order of the SDO. Page 37. Again, second paragraph, third paragraph, my lord. And whereas during the hearing on 11/6/2014, the appellant and respondent submitted a settlement minutes of statement held on 6/10/2012 between Sri Sanatan Kuru, Sulata, Subhash and NS Kuru, wherein they have settled the issues that the shortfall of land of Srimati S. Sulata be compensated by registering a gift deed, settlement deed to the extent of 50 square meter. My lord, shortfall, it comes, my lord, because she is having only 150 of square meter of land.
She is entitled to more.
No. How we can say, my lord? Because he has given only gifted only 150 square meter. Because he.
What does it mean?
Total, he had 6 children.
We are not on that. What do you mean by the shortfall of land? What?
If it is less than 150 square meter of land. Because the gift deed is there, my lord. As per the gift deed, only 150 she was entitled, my lord. Why the father will give more?
That is for you to decide. You assign the settlement.
Because if any shortfall is there. If any shortfall is
Very good.
there.
Now what do you want?
Now next come to, my lord, next page, 38. Demarcation was done, my lord. Thereafter, the report was prepared in the proposed map. Kindly be seen, my lord, proposed map.
Page 40.
40. They are saying 150. In the report itself, they have said, yes, 150 square meter is there. Whatever gifted, that is with her. There is a 3-story building, everything is there, my lord.
This is by the Tehsildar.
By the
This is the Tehsildar.
on the basis of the SGS report, on the basis of the SGS order, this report. And 50 square meter, what they have done, I don't know, my lord, because it's not written. It's not written. Kindly see, it has been, it has written thereafter erased or something, delete. What they have done, I don't know, my lord, but 150 plus dash, 200 they have written. This cannot be, my lord, because when demarcation was done, 150 was with the Sulata.
Very good. This is your argument. What is the?
Now the shortfall will not come. If there is any shortfall, then the and moreover, my lord, this settlement was done.
Then
in the
did
year
you-
2012.
Why didn't you challenge this page 41? 41 has sealed it. Your argument goes.
My lord,
Tehsildar says that if 50, then Mr. Shivamalam's argument comes that whether it is registered or not.
next I am coming to that. In the year 2012,
We are not on that. Why we listen to you? Madam, this page 41 did you challenge?
what?
You signed the settlement, etc., everything done. That is your interpretation, madam. That we understand. That is your interpretation. Now, why didn't you challenge this report of the?
Thereafter, what happened, my lord? Possession was never handed over. In the year 2017, they started demolishing my building because I have given only 150 square meter of land to my one daughter.
You are who are you? You are the daughter.
Father. Now,
Father has expired, no?
sense was on the basis of will, they are the entitled person.
That is in the present writ petition.
Presented petition.
So you are representing whom?
2 brothers.
Sudarshan and Suparnam.
These 2 brothers.
Hmm.
As per the bill, they are the entitled person, my lord. Because the bill was executed in favor of this person.
Very good. This is not your writ petition, it is their writ petition.
Now, my lord, in the year 2012, if they're done, within 1 month, they should have been given with the gift deed or settlement deed. Without the gift deed or the settlement deed, how the Tehsildar mutate the land, my lord? This cannot be done. Settlement deed, gift deed, as per the Registration Act, it has to be registered. It has to be registered. My father died after 10 years. After 10 years, they did not challenge. They did not come before this court, or they did not ask my father to execute the gift deed or settlement deed. After the death of the father, this petition has come over. During his lifetime, 10 years he was alive. After executing the settlement minutes of deed. Thereafter, 10 years they didn't say anything, my lord. In the year 2017 also, they started demolishing my building. That time my father, when he was alive, he has said, my building is demolishing. That complaint is also there, my lord. I have given a complaint because possession was not handed over. Possession, that 50, what they are saying, possession was never handed over.
Very good. Now what is your writ petition?
That is with regard to municipal, my lord. Without the building plan, they have constructed the building in the 15 square meter of land. That is with regard to.
Do have concern is the petitioner.
Petitioner hearing.
Petitioner has constructed the building.
In the 50 square meter of land without building plan.
Oh my God.
That is my case. It has to be demolished as per the building bylaws of the municipal regulation.
But there is a matter going on before municipal corporation. There is a stay of the municipal council. We have also filed a report that no further construction is going on. And that matter is going on before the municipal council. As well as
also,
lower court also they
they
have
have filed an application. They have filed an application to ascertain by appointing
But
a.
Mr. Kumar, if the deed was not registered, how it can be done now?
My lord, what has been fallen from my lord, it's absolutely correct. My only grievances is, my lord, there is an order of the authority. They know, my
The
lord,
order is this, come to page 41.
my lord. The application.
Conducted and the following field findings are mentioned.
Yes.
Area of 50 belonging to Kurup, which is to be registered in favor.
Favor of, yes.
Admittedly, this has not been done.
Yes.
So your writ petition, nothing survives.
No, my lord, here it says, in this connection, the application along with field report is hereby sent to settlement with, they know, my lord, what happened on the basis of an order.
No, Mr. Kumar, your writ petition was filed in the year 2023. You are seeking implementation of an order of 2015.
barred by,
Huh?
heavily barred by the limitation.
My
Even
lord, they government authority, they are under.
That you are wanting, your prayer is directing the respondent to register 50NR in the revenue records. This cannot be done.
No, my lord, I will not press this prayer. Why, what I am saying, my lord?
Then what will you press?
Yes, I will press, my lord, page 41, last portion. What I am saying, my lord.
Fantastic case here was.
My lord, may kindly appreciate the situation, my lord.
No, that is exactly what I am appreciating.
My lord, under the dint of an order by a statutory authority, my lord. My lord, what I am placing before my lord.
Yes,
There is an order of the
right.
authority.
All right, what does the order say?
The
Let us
order
come to
says-
page 37.
37.
Whereas hearing on such and such and respondent submitted a settlement minutes between such and such, wherein they have settled that the shortfall of land of Sulata be compensated by registering a gift deed. And as such, it is disposed of.
No, my lord, I only confine my argument to page 41, last paragraph. My lord, I don't know. I am a layman. I don't know what they will do. But the Tahsildar has directed the settlement, respondent number 2, you along with the is hereby to settlement. I say, my lord, what further action you take as per the direction of the Tahsildar in terms of the appeal which was disposed of. I am not asking anything, my lord, beyond this.
We could have done so had there been a registered deed in your favor. If your settlement was agreed to, that what she is submitting is that the requirement of 50 was contingent upon a shortfall on your part. That is hard argument.
No, that is contrary to page 40.
Why?
Page 40 clearly says 150 plus, that is 200. Clearly says. So that is those.
No. This is a surveyor certificate.
Certificate, my lord.
This is a surveyor, private surveyor.
Why this survey was conducted? 150 plus 50, my lord. That's why this was done. Otherwise, 150 I am holding. What, my lord, what is subject to
When you withdraw.
withdraw, my lord. We take appropriate steps, my lord.
Now after half an hour, you are withdrawing.
I am sorry, my lord.
Huh?
I am sorry because there was.
Let me pay someone. If something comes, let's take that.
I was arguing upon page 41 last portion because it's a government record which says you do this.
Now you satisfy me, why shall I allow you to be?
No, no, my lord, that's why I said, I don't want to utter even a single word, my lord. I am sorry, my lord. Some time was taken, my lord, with liberty to take appropriate step in accordance with.
So was there any order that both will be heard together?
There's a tag together, my both are.
একটু ওই ফাইলটা দাও মনোজ, পরের ফাইলটা।
Order. Tag.
কোনো অর্ডার আছে কি যে দুটো একসাথে শুনানি হবে? After both these writ petitions, so it was hard analogously. In the second writ, affidavits have been exchanged.
Yes.
But only the private respondent has given the affidavit.
Premiums have not given, I am not give affidavit in opposition. They are, I am on the alternate remedy.
No,
Given.
Premiums, premiums.
No, they have filed.
One report.
Just they are against you in that matter. They have not filed.
No, I filed, my lord. They have not filed.
And premiums are report filed.
Event किया.
During this stay.
It is the petition. Presently also listed in
ये बोल तो फाइल कर दिया।
along with the, oh,
वीक मेरे पास में आया था।
तो लेकिन हम लोग को कॉपी नहीं दिया।
नहीं।
नहीं दिया।
उनको नहीं दिया। क्यों नहीं?
TBMC का भी क्या है?
हम लोग को मिला।
हाँ।
हम लोग को मिला।
Well, Leonard Fund has filed an opposition, but no copy was served to.
Received copy.
that's asking. Um,
So they should know.
records reveal that Nineteen, can you file it with the, you can, what is the position of 19? What in 19, what did you pray? If I can dispose it of.
My lord, here in the trial court, everything is pending. In trial court, I will file their application where they say for conducting an
No,
inspection.
what have you prayed for in this writ petition?
They paid for stay.
No. First bit. My lord, here, my lord, the.
Yeah.
Building plan.
Writ material respond to take action as per 32.7 of filed by the,
Municipal council bylaws.
what is 32.7? No, give me a short, then I will hear you. 32.7 is what?
As per the municipal building bylaws, my lord.
Where is
prior
it?
to-
32.7 you have?
As per 32(6), they have to take permission from the municipal and only they can build the building.
You are the
Building plan.
You are the petitioner here. You are the brothers. So you have challenged in the writ petition the illegal construction being raised by Shulata in respect of that 50,
50 is.
in which no registered gift deed was there.
No, so there is no building plan. My lord. There is without building plan in the
You-
50 square meter, they have raised the construction. Have made an application before the municipal authority, municipal has given the stay. In spite of stay order, they have constructed fully. Now I want to demolish it as per the section 32(7). It is mentioned, my lord. If it is without building plan, it has to be demolished. That is my prayer, my lord.
Please.
32(C), 32(6) and 32(7).
32.7.
Well, 32(6) is the issuance of notice. Thereafter, we have 32(7). 32.7.
So that notice was issued.
Issued, well, the state.
So they have acted in violation of the notice.
Notice and stay. There was
So
stay.
you have asked for demolition of the building.
During the stay, what they have constructed, that has to be demolished as per section 32.7.
So any plan was sanctioned at all?
No, no. It's not in their name, mother. 50 square meter, it's in the name of the father.
So there is no plan at all.
There is no plan at all. Stay order was there. In spite of stay order, they have constructed.
Now, very good. Then what relief you want from me?
Well, it has to be demolished.
So where was that stay order?
Well, it's a page, my lord. No, I'll come to that.
So that,
Page 24, ma'am.
yes, so then what is the, why you have not taken steps, sir?
No, we have taken steps.
Civil
We
case.
have passed there is a civil case pending, my lord, before.
You passed an order.
We have passed a stay order. The construction currently is under stay. We have filed report along with photographs. But there is a matter going on before, I think on PBMC also there is a matter going on between the parties, the respondent.
My lord, may kindly see.
And there's a
this
civil
application.
court order also. The civil court
Can we
also the
see
matter
this
is going.
application under order 39 rule 7?
Civil
court. My lord, may kindly see what is this?
Civil suit is with regard
My
to,
lord, may kindly
it's
see.
null and void. That they have challenged.
No, my lord, may kindly see their application.
Saying that, because my lord, I have a plaint, my lord.
Once, my lord, may
They
see
have
that.
filed the case.
They are asking whether
Declaration.
construction was made, whether, my lord, may kindly see that ground.
My lord, suit for
Suit-
declaration that
Hmm.
bill dated so and so as null and void. This was the suit,
Which declaration of null and void what?
the bill which for 444. The bill was executed, my lord.
Oh, in respect of 440,
444. In
that is 439 one by one.
one by one, 639, one by one. With regard to that, the father during his lifetime, he has.
Achha, very good. You filed a civil suit for what? For
They have challenged it, bill,
they have challenged the will through the,
null and void.
oh, achha. In that an interim order was passed.
Interim application, my lord.
how can you file? They did not file.
Not this.
They are sued. You filed an interim. Plan.
Interim.
Then what happened?
In the interim order, that are not bad, madam. There is a specific, there is, after the inspection, the interim order, the interim application will be taken up. After the inspection,
What interim order you wanted?
madam, the construction was going on, madam.
So they want to stay up on the construction.
So how can you proceed under two different forums?
No, my lord, can you see that application, my lord? Can you see that application? Same prayer was made. My lord, can you see that application?
After
Whether
doing this writ petition.
this application was filed.
So, madam, we will,
File the.
madam, we will make it easy for you. We will say that since a civil suit has been filed by them challenging the will in which you have filed an interim application.
And an application under order 39 rule 7, my lord.
Interim application, praying for an identical relief. In that, is the municipality a party?
No.
Oh,
The declaration cannot be done, my lord, because that is the suit with regard to bill as null and void. That declaration they want. It is a genuinity of the bill.
then why did you enter your throat and ask for an interim order?
Madam, because-
You should have pursued this writ petition. You allowed him to take this.
Madam, in the writ petition, I filed the CAN application for stay. That was rejected. By saying that you will,
Where is that?
that filed it, madam. That also.
That was rejected because we have shown that there is no further construction is going on. There is a stay from the municipal corporate. That's why that can is rejected.
In spite of that, they were constructing, so I.
And there are.
No, we are given photographs. You can't do inspection and then given photographs that no further construction is going.
No, my lord,
No, very good, sir. Why the municipality will be dormant?
No, because there are rules and regulations and municipal which say that we have to give chance of hearing to both
So
the.
you give,
My lord,
you will not tomorrow go and demolish the building.
my lord, that's.
You give a notice to them, let them appear, let him appear, solve the issue, pass an order.
My lord.
That has no connection with the subsistence of the will or not.
No.
Even if you pass the order in favor of Mr. Kumar and the suit goes against him, then he loses all his right.
My lord.
but my lord, can you see that application order 39 rule 7, where the identical prayer was made by her and then a commissioner was now appointed perhaps. My lord, can you see that prayers, my lord? That whether that question which she has framed.
For appointment of a commissioner to ascertain the points mentioned in paragraph
Now, my lord, can you see the points? How two forum can you see the
the points are whether he has constructed new room or not, construction is attached to wooden house or not, whether new construction has been carried out. Commissioner will file his report.
Yes.
Court will decide whatever it decides.
Yes.
But we are not saying, we will say that the stay order which has been granted will continue till the disposal of the application for demolition of building.
No, my lord, what I am on, civil suit is filed. Now a commissioner is appointed, he will go and ascertain whether, my lord,
Whether it is whether any new construction is there. So suppose that report goes in your favor, that there is no new construction. Municipality, you will serve that you dismiss the case of demolition.
no, that is right, my lord, what I am on, my lord, since there is an interim order, let that be continued till the disposal of the
Which
suit.
interim order?
That interim order whereby the municipality has passed a stay order, no further construction be carried.
Huh.
Let it be existent till the disposal of this.
How?
But order 39 rule 7, my lord, identical prayer cannot be made, my lord, order 39.
This is not an identical.
Yes, my lord, absolutely.
It is a prayer for appointment of a commissioner for ascertainment of some point. Have he said that stop the building, stop the construction?
Already there is, no, my lord, we cannot see.
Filing the written of.
No, no.
Not accepting all these things, my lord.
Now, my lord, you see what submission my learned friend has made, whether that is there in the writ petition. Kindly see, my learned friend said that 50 square meter, they are carrying the construction, that's why we have approached this court. That 50 square meter where we are not the owner.
No, we will say it has been alleged by the petitioner that you are raising unauthorized construction without any sanctioned building plan. And this fact was reported to the municipality, no steps were taken, as such she has come. And in reply, we will record that you have filed a suit challenging the will on the rudiments of which she is coming. So that will is pending, and in that will, an application for appointment of commissioner has been passed. Now we will say that these facts will be placed before the municipal council while considering the issue of demolition. But you cannot make further construction.
Well,
That
we
has
are
to
not
be-
making,
My lord,
we are not making, my lord,
stay order was granted after ascertaining that the construction was going on. Then that is there, my
So
lord.
we are not vacating that order. That stay order we consider. Madam, today you cannot, you cannot demolish the building today itself. You have to wait. What is your prayer? You have also not asked that. You have asked that municipality should take steps for demolition of the building. So we will say that they will initiate, they have already initiated a proceeding for demolition.
My lord, that there is a stay order in that matter.
Which page, where is that?
But in my report, there is a stay order which I have filed, my lord. earlier.
there is a
Opposition.
report, my lord.
There is a report of municipal council, my lord. Yes, a report.
वही report.
In the affidavit from the file.
এখানে annex করেছে, এই যে,
Affidavit from the file.
has filed a writ petition. Oh, in the writ petition, you were asked to file a report.
My lord, we have filed a report. We said that no further construction is going on.
Because I have filed the CAN application, my lord, to stay of the,
For stay of,
stay, for staying, my lord.
My
Because
lord, they were
construction was going
alleging
on.
that
After-
construction is going on, this and that. They went inquired.
where is that application?
But CAN application was there, my lord, CAN one.
এটা কেন আছে নাকি গো?
Yes, my lord, that was disposed of.
It was disposed of by which order?
Filed on 23rd August 2023.
আছে নাকি গো? Any order was passed on this?
My lord. After 23rd August 2023.
Order may be passed for staying the illegal construction till disposal. That has been done.
No, no, no.
No, that, this was.
You file a CAN application asking the municipality to issue a stay order.
But that was, my lord, that was not done. Because
Stay order,
still they were carrying out the.
This was the allegation. Then the municipality was asked to submit a report whether any construction. Municipality submitted a report and
that
said
there is
no
no such,
construction is
no
going on.
further construction.
Going on.
the relevant.
So what has been
But
done?
what is the demolition proceeding clause? 32.7?
Hello, 32.7.
That is revocation of permit. Once there, you're saying there is no sanction plan.
No, no, there was sanction plan, no construction is being made, my lord, absolute. Very,
They will say, my lord.
Where is your sanction plan?
my lord, yes, everything is there, my lord. I can produce, my lord. It is not, new construction is not at all carried, my lord.
No, no, that is one thing,
Yes.
but do you have a sanction? Have you said that in your reply?
No,
My lord, just a minute.
He has not filed reply, no?
he has filed the,
I have filed the reply. I said that no construction.
he has not annexed anything, my lord. He has annexed only.
Arey, madam, don't go on saying, let him go through it.
The order and vacation only.
My lord, our grievances was that we are carrying a construction in the sideline. Our specific stand was that we are not carrying any construction. At no point of time, what has been argued, what has been addressed to the court, that without sanction plan, they were this and that was not the pleadings in the writ petition.
But do you have a sanction?
Sanction plan, I have constructed long back, my lord. There was no pleading to that extent that without a sanction plan, they were carrying. Their construction, their case was that we are carrying construction. We were carrying no construction, that is our stand.
Page 29 of the writ petition, he has annexed an inspection report.
My lord.
আচ্ছা ঠিক আছে, এটা তুমি ওই কবে রাখতে বলেছি?
Yes, my lord, on that way, I will also produce that.
Please produce on sign it, copy দিয়ে দিও,
Yes.
disposal. And madam, take, if you have that sanction plan, please bring this.
Definitely, my lord, I have constructed long back, my lord.
এইটা ওনাকে দিয়ে দাও।